Hey everybody, how are you? Happy Wednesday, happy live stream, my best day of the week. So anyway, for anyone who's not here normally, welcome to All Things Social Security and our weekly live stream Q&A. I see some people in the house. This is so nice. Hey, just give me a quick hello that you can hear me. Dimple, can you hear me? I see you down there at the bottom of my comments. I see Shiloh. I see Kevin Johnson's in the house. George Graham. Hi, guys. Good to see you guys. All right. Shiloh says, yes, you can hear, right? All right, perfect. Just like to double check that first thing. Just also a quick heads up, guys, that tonight, 8:45 Eastern time, I'm in the north. Jonathan Ginsburg's in the south. I'll be on with him tonight. That is the plan. I just got to make sure I can stay awake long enough. If I keep working until then, I mean, a lot of times I'll be working till like 10 anyway. It should work out fine. But usually my work at that hour is very silent, and I'm usually working on briefs or something like that, or reviewing. But yeah, so that'll be fun. I haven't seen Jonathan in a number of weeks, so we'll do a little collaboration there. So come join. Let's see. Where should we start? Looks like George is at the top. So George, thanks for getting here early. We have George. Hello. He's one of our, not mine, viewer, but prevailed in his claim. So he's got some little experience there that some of the rest of us might be, hoping to get to. George says, hello, question. Say I just turned 66 and want to volunteer or work 12 hours a week while still on SSDI. Do I need to file for ticket to work, or will SSA not give me a CDR age 67 is near? Yeah, I wouldn't. You're not earning any money. You're not doing SGA work, probably by and large. Even the value of what you're doing for 12 hours a week would probably not normally pay more than whatever SGA is this year. What is it? I'm always looking at the 1620 number. So I wouldn't be concerned. And it is not work, and they're not asking you for anything. It'd be different if you were doing a kind of, I suppose it would be different if you were doing high-end work for an entity where the value of what you're giving is SGA, and they could transfer that into work that would be over SGA. Like, let's say you were a lawyer doing something that would normally cost, $300 an hour, and you're donating 5 hours a week. I don't know, maybe then they would, if that's something that could otherwise be paid for. It doesn't mean, even though it might be worth that if it were paid for, if there's not a market for it, and that's why the person's volunteering. So I wouldn't be too concerned about that. And I definitely am not concerned about a CDR since you're so close to 67. So I wouldn't worry. Okay. And I hope you enjoy volunteering. You can also work a little bit for money. And particularly at 67, when your SSDI automatically flips over to retirement and you are no longer on the ranks of the disabled, you can certainly work and earn as much as you want. So that's the good part about that. All right. Kevin from Tennessee. Hi, Kevin. Shiloh says, and here's the next question. Thank you for your time. If you had a severance agreement with your job due to not being able to continue to work due to PTSD, for instance, should I put my onset date the day after my last day of fulfilling working? Yes, I would. I would put it's when you stopped working, not when you got a paycheck that would equivalent to 6 months of work thereafter. It's when your work activity stopped. Okay? Remember, there's multiple questions and how the SSA asks it. I assume you're talking, Shiloh, about an application, maybe? You'll see, I actually had a video on this not too long ago, the different ways that they ask about work dates and how to look at them all on the application. Because they do ask different ways. When do you think you became unable to work? When did you stop working? And there's a third way. And it is to see if when you stopped working, maybe you actually were disabled under the rules before then, because maybe your work was not SGA. Maybe it was not SGA in gross hours or amounts. That's one thing, some sort of part-time work. And also it could be that it was, even if the money was over SGA, they also give you the opportunity to say, yes, but some of that stuff was impairment related work expenses. So I could just subtract that from my countable earnings from work, and it might drop a person below SGA, and then they can actually pull their alleged onset date further back, which might potentially be found to be substantiated by the medical evidence. And then they could have 6 months more or a year more back benefits, which would be super beneficial to most of us, right? But yes, I would say unless you're working very part-time and under SGA, Shiloh, before that last day of fulfilling working, if you've been working part-time before then, you might want to go back even further for your alleged onset date. Shiloh has another question. If I could get it to click on, would be good. Would you upload the settlement agreement to show, 1, the last day I worked, and 2, show the money I received after wasn't due to work but due to something? No. Just tell them what day you stopped working. If your company sent you money after, it will generally be in a 1099 possibly, or a W-2. And usually it'll have a little notation in it that says what it was for, that it wasn't for work activity lining up with that. I wouldn't send them your private settlement agreement business. And I don't know what you were settling on. I know some people are like, well, I settled because I was discriminated against, and that's why I got fired. And for purposes of SSD, why would you share that? Well, because they feel like they're justified in something, and therefore I've been through this hardship, and therefore I'm a good person. I don't know why. Because you're now, by putting that forward, by sharing what was not asked, you're just basically telling the SSA, I didn't get fired because my disabilities were not making me work well, because they're bad people and they discriminate against me. But I was able to do that job because, remember, for disability discrimination type of claims, it has to be where, like, let's say a reasonable accommodation that would allow you to be able to do the job, still not be able to do the job, but we got to keep paying you anyway, even though you're doing a crappy job. So when people, they want to fight that I was a good worker, I did really, really well, and it wasn't even just that they got rid of me. Well, what are you trying to say? That you didn't become disabled and therefore couldn't do your work? Or you are? It's almost like they're fighting their own case because of this mindset, that they have. So, pardon me, I have my fan on because I don't have air conditioning in here. And we've had some nice warm piping days. But it blows the hair in my face a little bit. It's not even on very much, but I'm trying to keep a little. So I wouldn't do the settlement, Shiloh. I would, A, your statement should be more than enough. B, your last pay stub should show something. And if you don't have a subsequent pay stub that shows something else, like here's my last pay stub, and then if you get something at the year end, it should kind of describe it. Sometimes with those payments, there'll be a letter that says it, not a settlement, but it'll say, here's your severance pay. And you could also probably ask HR for a date of last worked. And then they'll know that this was the day of last work. All the other monies are other vacation or pay or, vacation, disability, sick days that you didn't use it, you're entitled to get paid for if your company does it that way. So there's other ways to do it. I just wouldn't let them get in on your, if it's a different kind of legal battle like the one I just mentioned, because I can come and present a different light. Shiloh says, this is the next question. I know you stated 8 hours of working, sitting, walking, standing. 8 hours of work. But just to make sure I got it, stooping, crawling, etc., that isn't. No, if you look at the work history report, and if you're doing the application and you only had one job in the past 5 years, you're going to see this on there too. Otherwise, you won't see it. It won't be triggered. And you'll have to do a full-blown work history report. But on the work history report of the application, when they ask about that job, it even says, just for the sittings, now they combine standing and walking, which makes things much easier. They didn't used to do that. So the standing and walking, so on your feet versus sitting, those two things should, if it's a full-time job, if it's an 8-hour day job, should total 8 hours. And that's by and large makes sense. Now, being on your feet, standing, you could be standing in a squat position. You could be standing in a bent over position or stooping or whatever. So all those, it doesn't matter. That standing and walking that you talked about is all the time on your feet. Basically. Now, those are separate. I would, if you're sitting, they probably wouldn't include those, but they don't get too nitpicky because I know work can be variable. Some days, you could be crawling up to an hour, but some days it's only 2 minutes. Like let's say you're a preschool teacher or a daycare center and you have to watch the babies, and sometimes you have to crawl under the cribs to get the little binkies that fell out. Some days you're like maybe feeling like you're crawling under there all the time, and then other days you just did it once or not at all because no one tossed their binky out. I'm just giving an obvious example of someone who has to get on their knees probably quite a bit and do some crawling. So sitting, standing, walking, make that your 8-hour divide. The rest of it can be kind of whatever it is. And I always say, go for the maximum of a not unusual day. Like on any given day, if there's 5 hours of kneeling that's needed for that, let's say it is that little daycare center job, and you have to be able to be on your knees quite a bit, there's going to be no set time. But if that job says, you have to be on your knees for 4 of those 8 hours because you're playing with the kids, you're going under a crib or what have you, that's what you have to be able to do, then I would probably put 4 hours. It can be up to 4 hours. They don't really give you they don't give you a range, if you notice. So then I would go with the one that depicts what your job required. It required that if needed, I had to be on my knees for 4 hours. Didn't mean I had to do it every day, and sometimes at a hearing, the judge will say, but really, how often did that happen? And the person might say, well, that only happened maybe once every 2 weeks, but that's where the details can be fleshed out. But if it's like, yeah, no, I'm expected that if it's a 4-hour day, I got to do it for 4 hours. So I can't be like, oh no, this is my 5-minute day. Let the kiddies go wander themselves. Responsibilities are responsibilities, particularly when we're dealing with other human beings. Shallow goes on to say, so this is the next question. My job was computer service, but I did about 5 jobs. Oh, customer service. Did I say computer? I did about 5 jobs under being a rep. They said due to that, it's considered a composite job. Ooh, composite jobs are usually favorable for you. Can you explain that more? Is it worth me explaining that? No. So I think you're saying, did you have your hearing and they said it was a composite job? Refresh me on your history there, Shiloh. I don't recall. Yeah, I just tried to argue one was a composite job in the last couple of months at a hearing, and the judge was like, didn't even want to broach it. But it was a composite job. It was like 50-50, but they wanted it to be all the one side so that it was an easier physical job. That helps them deny it under a grid better. Not that I think he's denying her, but it might, it will take a different avenue. But I thought clearly it's a composite job. The title shouldn't matter. If someone's called a buyer, but half the time they're stocking shelves, for that company and running the storefront, then that seems to me like a composite job. But that's just me. And I'm not an expert on composite jobs, but, my information on that. So if they're saying you had 5 jobs kind of all in that role you played, sometimes you had to go get coffee for the boss. Sometimes you have to do that. So you were the one that had to clean the toilet. Like at the end of the day, make sure the bathroom's cleaned up. Those are things that I think add to, particularly if they take up more than like 20 minutes of the day, a composite job. And the beauty of a composite job is they can't take the one big job you had, the one that has the name, because you had to do all these other things, and then assign that to you as to past relevant work that if you could still do. Because you're like, no, that isn't what all I did. I had to do this. This thing called, sometimes I had to lift a 5-gallon jug of water because I was responsible for keeping the employee water station stocked in the water cooler. So that was every 2 days I had to lift a 40-gallon bottle of water and carry it, 20 yards from store, stock to blah, blah, blah. Those are all the things that, I would try to add in, because then you're more of an assistant, an admin assistant that has to do all those things. and maybe you're doing the other stuff less than full time. Maybe that other job that you're titled as, you're only doing that 5 hours out of the 8 hours because 3 hours a day you did all these other things. Maybe you were doing, well, like you said, you were doing customer service, but there were other things you had to do. And that's not unusual for companies to, you know, save money. And I get it, save expenses. Like if you have 5 employees and are you going to hire a 6th just so that they can make sure that the toilet paper is still on the roll, so that if a customer needs a bathroom, you know, there's toilet paper. So that one job might be housekeeping, but they're going to make one of the 5 people that are doing the, I don't know, reception work or whatever the job is, do that too. So they don't have to hire a 6th person to do something that takes 5 minutes twice a day. And when all that stuff adds up, you know, it could turn it into a composite job, I believe. Never hurts to make the argument. Hey, Oscar. How are you doing? Hello, thanks for all the great content you put. Oh, thank you. Good talking to you. Shiloh again says, this is the next question. And I appreciate the questions, by the way, Shiloh, because people get a little slow asking questions when we first start out. So that's all good. Don't feel bad about asking a lot of questions. Shiloh says, how does SSDI view receiving unemployment benefits for about 3 months and having a settlement agreement due to not being able to work? It's from the same job and haven't worked since. Okay, so 2 different things here. Currently, under the law, and I don't think any state has changed their side of it, which is the unemployment side, and neither has the SSA rules. Receiving unemployment doesn't get offset or anything with regard to, so let's say, let me give this scenario, guys, for everybody else who, you stop working because you have an impairment that prevents that job. Maybe that job, you had to lift 50 pounds and now you have a back problem and the doctor says you can't be doing that. All right. So you have to either get let go or you resign for good cause from that job. You apply for unemployment. Now remember, and this is where it gets kind of in the weeds, unemployment in most states generally says, most if not all states says, you are willing and able to work. So here you are, you left one job saying, I'm not able to do that job. In fact, down the road, maybe a little bit, you file for SSD. But in the meantime, you just come out of the job and you're like, well, I'm not useless. I'm going to get a job I can do, an easier job. And this is what's in your head because you're a worker and you're like, I've got to pay my bills. I'm going to go get a different job that I can do. No longer lifting 50 pounds. So the person files for unemployment because they are willing and able to work. They just can't do that job. And they didn't lose that job through default. It was due to not being able to do that job, not because not being able to work at all. And unemployment might be available. So now they're collecting their unemployment. And then maybe a few months in, they hear through the grapevine this thing called SSDI. And hey, if you think you might be out for more than a year or more due to your disability, you could, consider filing for SSDI, even if it hasn't been a year yet. Okay. So then you file for SSD. You don't even have to talk to the SSA about unemployment, particularly the lower levels. It never comes up. It might, if they say, did you get any income through the year? You might want to say, I got unemployment from this date to this date. And let me just explain quickly how it is not inconsistent, by and large, to file for unemployment while also saying, I'm not able to work and filing for SSD. And here's why. SSDI, you're not saying you're unable to do anything. You're saying I'm unable to do one of those 12,000 jobs that exist in substantial numbers in the economy on a full-time basis, 8 hours a day, 5 days a week, week after week after week for at least 6 months successfully. That's what you're saying you can't do, one of those jobs. You're not saying there's not some job you can't do that you can do. There could be there's some jobs that are really cushy. They're not in big numbers. That's why none of us have them. And they don't count for SS purposes in terms of, is there other jobs you can do? It's only the ones that exist in substantial numbers in the economy. Substantial or significant. So when you're filing for unemployment, you're saying, I'm willing and I'm able to work. You're not saying, I'm willing and able to do every job on the planet, including the ones that lift 50 pounds. In fact, I can't lift 50 pounds, but I could do something else. I'm sure of it. And I'm applying, and I'm, you're supposed to be applying. So the two are not inconsistent for most people, I think, who file for SSD. If you get someone who just usually due to ignorance, not due to malintent, can't do the job they're doing, maybe because they just couldn't do it mentally anymore or physically, but they feel very, very well able to do something else full time. And it's not just like, well, I don't even know if I could do a full-time job because my back is humming whether I'm sitting or standing, and 8 hours a day of that, regardless of what I'm doing, it hurts. So I'd be better off with a 4-hour day part-time job, and I think I could do that. But the person who knows they can and then is just like winging it to see if they get SSD, that's kind of a different story. But that's not most people. And that's why I think most people file for unemployment, have all intentions of finding another job they can do, and then they find out, I really don't know that I would be able to do 8 hours. Even at that sit-down job, my back hurts when I sit at the kitchen table for breakfast. Or, so a half hour is hurting. Or, I get winded when I walk to the mailbox. So I think people start to realize some of the more limitations they have once they're home and they're not in that tunnel vision of the job when you're at it and performing it until you can't. So unemployment, SSDI, not necessarily inconsistent. I will warn you, however, that if you go to a hearing, and I have not heard this in years, it's probably been 5 years since I've had a judge ask about this. And a lot of my clients have been on unemployment until they realize, maybe I really am disabled from most of those 12,000 jobs. Sometimes a judge will say, and I assume they still do it, I just haven't crossed my path. Yeah, I see that you are collecting unemployment while you're also claiming for the same period that you're claiming that you're disabled and not able to work. When you filed for unemployment, didn't you say you were able to work? Now, if a person's not prepared how to answer that question, I could see that would be a little bit of a, sometimes they'll say, well, I needed money, so I didn't know what to do. That's not really the full answer. The full accurate answer, and I've never seen an answer differently in reality, is that, well, at the time, Judge, I thought I was going to be able to do another job. Like there would be something I could do, and I was applying, and I thought I was going to try, and it's never been a reason to deny the person, because sometimes the judge will ask it. So not a bad idea to be prepared as to the reality of what probably occurred with you. I really thought I was going to be able to go back to work, or at least find that really unique job, that is kind of cushy enough for me. You can even say, if it's accurate, like I was looking for a flexible hour one and part-time, and or maybe there was be like a morning hours and then afternoon hours, so I could rest in between. Yeah, so I felt pretty sure I could probably do some job like that. And guess what? Those split shift jobs, they don't exist in substantial numbers in the economy, I don't think, and therefore that wouldn't have counted anyway. And it's not like you have to know that law when you're answering a judge who asks this question. You just say, I really thought I was going to be able to find a job I could do. I didn't realize that the kind of job I could do was so rare. And now you just kind of zinged it about that not being in substantial numbers, even though you're not quoting the law to him, because that would look a little pre-planned. So anyhow, I hope that gave you guys some information on that, because unemployment does make people worried. Or else later on when they file for SSD, they go, oh, but I filed for unemployment. I'm like, no worries. Not a worry whatsoever. Okay. Hey, Beth is in the house. Hi, Beth. Good to see you. Gorgeous weather in Georgia, she says. So I will be live streaming from Georgia, Beth, with Mr. Jonathan tonight. Let's see. So feel free to pop in, people. Rolando says hello. Hello, Rolando. Okay. So we got Nina in the house. Nina A. Hi, Nina. I don't know that we met. It is nice to see you. Nina says, this is the next question. My CDR diary date came and went. I'm 63 and no review yet. You got like 4 years. If you know, Nina, that you are not medically improved, not that I don't want you to be medically improved, but that's the most comfortable place to be in terms of a CDR. And if you have continued to follow up with your regular physicians, including the specialists that you might have had before when you prevailed. As long as you're doing reasonable follow-up, it's not necessarily the aggressive follow-up that we were doing when you were applying. Because you're trying to prove and get something over a hump. You got it over the hump. Now it's kind of like copacetic. So unless you know that there's some improvement that's going to show up in those records, or you're working now and you weren't working before, that kind of thing. I don't like to see people worried about a CDR. You really shouldn't be, unless you've kind of slacked off on your treatment, or like in a way that would indicate improvement. Or if you had the kind of impairment that is, let's say it's cancer, and you're expected to, go through a treatment and then it be in remission, then I could definitely see that's going to be a CDR, and probably, God willing, there's improvement, right? So unless there's something else that stemmed, like a lot of times, some treatment for cancer really kills the stamina. It does something to our particular systems in there. And I've had a lot of cancer clients post-cancer who, what was the way one of them put it? I have a limited gas tank. And so maybe 2 hours of mild activity at home that she could do just fine. She could do the dishes. She can do the little one. But 2 hours of doing stuff, then it's crash and burn for like a 2-hour nap. And it's like the body refuels itself. The brain, sometimes it's also the brain fatigue. And after being up for a while, they're starting to get a little foggy and maybe missing things. And just really, it's like a whole different change from 2 hours prior, when they were refreshed, had just gotten up, had breakfast, whatever. So, cancer can be a funny thing in terms of the law in this area, because if you're recovering, that's an improvement by definition. But there can be some sequelae that will, continue on forever, that might not even have started or wasn't noticed and complained about when you're in the throes of the treatment. And then it's the fact that you don't bounce back from this chronic fatigue. Gas tank is only half full type of thing. Or that sometimes the brain fog, even though, sometimes the brain fog is just constant. So every impairment is different. But if it's that kind of impairment, I would expect to have a CDR. And if they're a little late, that's because they really did put the CDRs a year or two ago, probably 2 years ago now, on hold to direct those workers to handle initial and recon claims, appeals, and let the CDRs sit. And then they were trying to get them all taken care of. So it may or may not. And I will also say it's probably true that the last people they're going to go, like if they have to, it's like prioritizing, like the government has to do with everything. You take the most cost efficient things to prioritize, the ones that are most likely improved, the ones that are younger and would be collecting for another 20 years if they're not CDR'd and they're not disabled anymore. Whereas 63, there's only 4 years up. Is it long enough for a CDR? It sure is. However, you know what I mean? It's probably not going to be at the top of the list. And then, of course, depending on what the impairment was, it might not. Like, were you a 5 to 7 year anyway? They might just be blowing them off. They don't tell us that, but they could be. If they're going to deprioritize something, you'd think it would be those, because those were medical improvement not expected. Dimple says, and I know this is I think I'm going to scroll down because you got cut off, didn't you, Dimple? Let me go to this one. Next question. Rotator cuff is torn completely, and doctor has stated that recovery will be at least 1 year. Application has been filed due to a different impairment. How does the SSA look at multiple impairments? I will say this. It's likely that your application was not filed due to a different impairment. It was probably filed with a list of all impairments. And the shoulder is huge because shoulder injuries or impairments affect our lifting. And our lifting capacity is what affects whether we are going to meet an RFC of medium or not be able to. Remember, medium exertional is 20 to 50 pounds. Lifting, with a shoulder, lifting that amount of weight, I would think with a completely torn rotator cuff would not be advisable, if even doable. So that shoulder injury can get your exertional down to a light or less. And if you're of the age frame where light or less is what you need for that one prong of the grid applications, then that's the one prong of the grid applications. You had to get reduced to light or sedentary. There's other prongs you have to meet. As you know, you have to prove you can't do your prior job for some reason, and you have to prove that you would not be able to you either don't have transferable skills from that job, or you would not be able to transfer them to a less arduous job, say a sedentary job that you could otherwise do, right? So you might have gone in for XYZ for a knee or a back, and I don't think your lawyer is going to leave at your shoulder. I don't think even the lawyers that only want to put in 2 or 3 impairments wouldn't probably leave out a shoulder, because that's directly on point with lifting capacities, right? And for the over 50 crowd, that's imperative that you rule out at least medium work. All of them, everybody over 50 has to rule out medium level work to meet that prong of the grids. As we get older, like 55, we can all we have to do is carve out the medium. When we're under 55, that's when we have to also carve out the light. But everyone has to carve out the medium. Christina's in the house. Hi, Christina. Hope you're doing. Hello from California, she says. Oh, and so importantly, she says, please share the live stream. I appreciate that, Christina. She's always such a help. Oh, and here she goes some more. Please don't forget to like, share, comment, and subscribe. I appreciate Christina. She's always the reminder for everybody. That's great. Shiloh, what are you apologizing for? Oh, Shiloh says, I apologize. I kept saying settlement, but it was severance pay, which is actually kind of the same thing. It is kind of the same thing. Although settlement implies there was a battle, and severance pay might be where they just want to do it for their employees that have put in a certain amount of time. It might just be part of the either they made it a mandatory within their company to do severance pay, just as it's almost like a universal employee benefit they opted to have. Or I will say this, I've never seen a severance pay go out without the employees signing that they're not going to sue. So I think it's almost like part of we're going to be kind, but we're going to make sure there is some consideration for this, and that employee, even for something that we don't even think there is any gripe, they're going to mention a gripe, we're going to close that door now, by and large. Dimple says, I'm just thinking that they might consider the arm-hand arthritis to be linked to the rotator cuff. Not really. And may give less consideration to the RA. The RA is more systemic too. It's usually affects a lot of body parts in a lot of different areas. My doctor suggested that RA may have caused the rotator cuff. Well, yeah, I suppose so. I mean, I'm not a medical doctor, so I don't get into what's causing things, but it doesn't matter what caused it. Let's say what caused it was you had a car accident and your shoulder got jammed up. I mean, that's a cause. It doesn't matter as long as it is a limiting body part. Can you guys hear all those animals out there? There must have been like the UPS guy or something, because one barks, then they all look out the window, then they all bark. They're like a mob. I had a video that probably hasn't gone out yet, but in it, I was talking about function report, but I said something like, because I heard the dogs barking. I don't think you can even hear it on the video. And I said, oh my God, I can't. Even in the video, I'm like, I can't wait till I'm pet free. I'm like, I got another 5 or 6 years. And I let it stay in the video. And I'm like, yeah, I might upset a couple of animal lovers, but I'm not. I keep my animals. I take care of them. I just don't want them in a few years. I just want to be pet free, by and large, pet free. There's 4 dogs out there right now. I would yell at them right now, but I would hurt your guys' ears. There's a way I can I should set the ring off. There's a ring out there and I can make it go. And it could freak out. Make it blare. I mean, they usually shut up eventually, but they go longer than if there was one dog because one barks, the most neurotic one barks again, and then they all start barking again. They're like, I'm sorry, they're not the brightest. Welcome, Shiloh. Cannon from the county. Ah, you're filling up the 3373. You probably already know about it, but there's a whole playlist, Cannon, on function report. And everything from like the last few years is obviously still applicable. But I am adding more stuff this year. I just decided a couple weeks ago. I'm like, it's been a while. Because things come up that you see in real life, in action, and why not have, oh my gosh. This is why, guys, I want to do something to them. Forgive me. Just give me 1 second. I want to figure out how to. Can you hear that? I don't know if you guys can hear the siren. I don't know if it's going to, I don't know if it's helping. It goes on for 30 seconds. Canada says filling out his 3373. That's the function report, guys. My lawyer sent a walkthrough PDF. Oh, that's sweet. Cannon says, what is the number one thing that I have to avoid wording wrongly? I wouldn't know the number one thing because there's about 500 of them. Remember, it's kind of like saying, what are all the things you shouldn't do that could get you killed? There's millions, so you can't really say which one. Just don't do anything that's going to give you a bad answer, I suppose. And I'm not sure if you are aware of this. If you're not aware of the playlist, they go by number. So you know how like some are kind of common sense, you think, right? But let's say you're having struggles on number 5, which is a big one, number 6, number 20. Those are just individual videos to keep them kind of short so no one has to sit through the whole thing. So there's multiples on like the 5, and there's multiples on the 20, and and the 6 and some others, because there's at one particular time, like you're not going to get everything in 10 minutes anyway, but if something comes up and you're like, oh my God, that person put that, like this is something people shouldn't do. And you start to think like, oh, there could be other people that did that, because depending on their, I don't want to have to walk out of here and go smack these dogs, but I'm going to give them a verbal what for in about 2 seconds. Dimple says, I'm probably overthinking this. Wouldn't be the first time I've been accused of overthinking. That's okay. Better to overthink than underthink. Cannon, going back to you, the one thing I was talking about last night was, I think it was the one about going overbroad, like in number 5, because it wasn't more about number 5, but it was about, some people say, I hurt, because it says, what are your conditions that stop you from working? I hurt my back and I can't work. Put in your application. And they're going to get it the medical records. So what is it about the work, the back condition as it stands now that prevents work-related activities? And I always say, look at number 20 to see what the broadest of work-related tasks are and compare it with all those. And also, don't just say why you can't do your old job, because there's 12,699 other jobs that they have to consider. So if you're just talking about your past job, that's not going to get you through step 5, which is about all other works. People do that a lot. And I even say, I think I'm talking about like construction workers and stuff like that. People that have done a lot of heavy work. They're like, I can't do it because I used to lift 100 pounds and now I can't do that. Well, all you've done now is describe how you can't do heavy work. What about the many, many thousands of other jobs? So I would bring it down more to the basics. Why, sitting, standing, walking, how restricted that is, that would prevent even a sedentary or light job. Guys, hold on 1 second. I'm going to go kick some serious tuchus. Okay. We'll see how long that lasts. They were barking at nothing, by the way. Nothing. Not a thing. A leaf blows. A squirrel, you know. Again, it's the mob thing. It's just like they get in this big party of fun. They think it's so much fun. They're wagging their tail the whole time. Kind of one more thing. Try not to use extreme language like I never, I cannot ever, I always. I probably wouldn't say my pain is a 10 out of 10, because if it was, you wouldn't be filling out a 3373. So, because very rarely is something never, always, right? It's just not. It could be most of the time. Geronimo. Hi, Geronimo. I don't think we've met. Have we met? I don't think so. Gutierrez. Okay. Good afternoon. So this is the next question. My question is, why am I needing a CE since the vocational expert said I don't have any transferable work skills? I have coronary artery disease diffuse. Because the CE is not about whether you have transferable skills. The CE is about how limited you are. So what, you know, when the CE, consultative examination, and consultative examiner examines you and sees your strength in your fingers and whether you can do a squat and heel to toe and all that, it's going to be about that. Unless it's a mental one, in which case it's going to be mental things. But yeah, so the CE is a medical person, not a vocational person. So it sounds like you're having did the judge order a consultative exam after you had your hearing where the VE testified? I just had one like that, and that's rare. I even said to the judge when he suggested it, I said, but judge, it was a remote DLI. So I said, what the point of a consultative exam now, it's a snapshot today of the person's condition, and we're trying to prove that the person was disabled 3 years ago or 5 years ago or whatever under those medical, you know. And he's like, that's true, that's true. But then he went and scheduled it anyway post hearing. So I don't know. I figure it can't probably hurt. The judge seemed nice. Maybe it was just to help solidify that at least as of now she is, and if you can bring it back to the DLI that's, you know, not so far in the past. Like it wasn't the 3 to 5 year DLI. In this case, it wasn't. David says, so this is the next question. SSDI status from Appeals Council has disappeared from the website. What happened? I don't know, because I don't really see what you guys see, you know, on your phone or whatever. Oh. I hope you guys didn't hear that. I muted it while I yelled at them. Okay. It could be that the Appeals Council has made a decision, and you'll get a letter soon as to whether they decided to remand or decline to review, which is the way they say or not. We have a new member. That's super sweet. This is Screamin' Eagle. Hi, Screamin'. Do you prefer Screamin' or Eagle for short? But thanks for being a member. That's awesome. I appreciate that. Shiloh. Okay, so next question or comment. Awarded 100% P&T in September 2025. Okay. Glad you got through that hurdle. I am sorry that you are 100% P&T though. And I thank you for your service, of course. I think I thanked you the last time. All of my treatments were with my personal psychiatrist. I'm requesting SSA to contact her for medical info, and they will, to get it expedited due to 100% P&T. What is needed to as long as they know, if you have your documentation from SSA saying that you're 100% P&T, I would send it to the field office. I would also just send it to the adjudicator just in case this doesn't. It would probably be the field office, though, that does it that way. you know, when we apply somebody, we kind of like make it clear there when we send in our documentation. So, but we tell them if we don't have the documentation, like this is 100% P&T. I would like to think the SSA can go get that information themselves. I'm sure they can. Like, I'd like to think that they actually do double check people, because imagine if someone was impostoring and just saying, I'm 100% P&T because they want to get to the front of the line. We wouldn't be the first time, right? Yeah, so Charlotte's talking about proof of 100% P&T. Yeah, you have a letter, right? How'd you learn about it? Can you go onto the VA website and just get the confirmation letter? And then, you know, through your account and shoot it up to the SSA? Screaming Eagle says, hi, Stephanie. Glad to be part of the crowd today. I'm glad you're here. If somebody has this is the next question then, guys. If somebody has a CDR in 7 years, which makes you 67, which then puts you into Social Security, well, it puts you into Social Security retirement versus Social Security disability. Yes, both are Social Security. Both are your Social Security. Same amount. Anyway, the question is, do you need to concern yourself with a random exam? I wouldn't be worried at all. You know, they're probably going to continue on with the 7 years, and that's because they don't expect medical improvements that would make you able to work under the rules. And, you know, short of doing something like working and earning, which changes the whole optic and means you're potentially improved, because before you weren't able to work even part-time, or at least you were not working. So it could, you know, in some way, form, it can be evidence of something, but isn't necessarily mean improvement, and doesn't necessarily mean improvement enough to go back to work full-time at a job that exists in substantial numbers in the national and regional economy. So all those little fine words are what help us. Okay, we've got CG. Hi, denial here, under 50, turned 50 in December. Refresh me, CG. Were you denied by ALJ, or were you denied underneath, you know, at the lower level? Cannon says, I've been watching your videos. Thank you for what you do. This helps so many people. I appreciate that. Thank you for chiming that in. That was really kind of you. Sharing it publicly like that. Oh, Cannon's from West Virginia. I love West Virginia. I'll tell you, if my husband didn't work in Pennsylvania, in the capital city, I would love to move to West Virginia. I'd like to get a big old piece of land. I don't want to see my neighbors. I want to see them when I want to invite them over, or if they want to invite me over, but, you know, sorry. Does that make me antisocial? I don't think I'm antisocial at all. And when I go out, I'm not. Like, on the rare occasion we get to go out and, you know, have a little fun, I'm as chatty then as I am now. Okay, Cannon says, your number 5 videos view count has gone up this week for sure. I think did I turn off view count? I think I might have turned it off. I don't know. Oh, no, maybe I didn't. Yeah, you can't turn that off. Okay. 3D's in the house. Next question. Hi, 3D. I hope you're having a good day. And it's nice to meet you. I don't think we've met. What should someone expect at an SSI disability remand hearing after the appeals council vacated the ALJ's unfavorable decision, especially if their attorney withdrew right after the hearing? Oh, that means you can get a new attorney. Did he withdraw and waive fee? That's the big one. Well, what it means is you're either self-representing at your next hearing, or you are getting a new representative. Your choice. You know, well, presumably your choice. Did the attorney withdraw right after the hearing before an appeals council appeal was filed? Did you appeal it on your own, or did he file it for you and then withdraw? Why would he do that? I guess he just, I don't know. He didn't have a lot of faith in it, I guess. Well, I could see not having a lot of faith in the appeals council remand, because that's not that, you know, 15% or something. But still, like, no harm, no foul, just to wait. Cannon, you're welcome. And I appreciate that. I really appreciate that. Cannon goes on to share, Cannon was in an accident, TBI, that would be traumatic brain injury, for anybody who doesn't know the acronym. back broken in 2 places. Oh my goodness, Cannon. And 2 broken ribs. Diagnosed with 2 psychiatric disorders. Were those stemming from the TBI or were they pre-existing? Yikes. I hope you are in a good recovery. Geronimo says yes. My mind is like a sieve. What did I ask you, Geronimo? Oh, okay. So my expectation of where the what happened that you got a CE by the judge. I'd like to think, and this is pure speculation, Geronimo, I would like to think that a judge isn't going to put money into the CE unless he's thinking of awarding you, and he just needs to double check something. You know what I mean? Like, that's cost money to the SSA. I'm sure they don't want to see it done. I'm assuming, you know, they get checked on how much they're spending out of that ordering they can do, and if someone's constantly always doing it, like I said, it's not that common, a CE after a hearing. It's really not. Sean Bailey's in the house. Hi, Sean. I don't think we've met. So Sean's question is, I was with the Postal Service for 27 years. I was injured on the job in 2024. So you probably have a workers' comp or something. Are they self-insured for workers' comp, I think? Maybe. I'm also legally blind with 15-degree visual field test in both eyes. Ooh. Oh, are you asking if you qualify for SSDI? If your definition of legal blindness meets the listing, so you're going to want to go precisely and get the exact medical records that show that you meet the listing as explicitly defined in the listing, I think you would, as long as you're not doing that Postal Service job anymore. Did the injury cause the legal blindness? So all injuries, all diagnoses can potentially be legally disabling under Social Security rules. The question is more so, does my level of severity for one or more impairments render me unable to perform, you know, any of the 12,000 plus jobs found in substantial numbers in the regional and national economies? And that's going to depend on your particular severity, right? We can have 2 people can have a bad back. One guy can be a cashier doing light work for 10 years, and one person can't even walk across the room without pain. So, you know, there's impairments, and then there's varying degrees of how much they limit us from functional tasks like that. Geronimo also has a ripped rotator cuff. Sean Bailey is 54 years old. And Sean, just to refresh you, what I was just talking about, guys, was in the Postal Service for 27 years, had the injury, and I'm so sorry for that, in 2024. You're still in that lowest level of grid assistance between 50 and 55. I'd like to see people win before they're 55, because I hate to see the old push always to, well, we think you can do light work. Your big goal, you know, you have to be able to, unless you're going to win on a listing, by and large, you're going to grid out, Sean, you're going to have to show that you cannot do light work. You can't be on your feet for 6 to 8 hours, and or you can't lift more than 10 pounds. So that's something to look at. So it's going to depend. That's going to depend. That's why I'm always pushing my people over 50 when they're doing more systemic problems, like, well, I have diabetes and I have a gastro, this and that. I'm always pushing on the biggest snag. I know them really bad. Let's go with those musculoskeletal things that are not the thing that really disturbs you the most, because they're the things that are they're the only things that are going to get that potential medium level work that's 20 to 50 pounds being able to lift occasionally, knock it down to light or sedentary. And depending on the person's age, is how far we need to knock that down. And you're not going to do that generally with systemic issues. It's going to be specific musculoskeletal, the joints, the back, the shoulders, the knees, the ankles, the the hips, and everything. That's to meet the one prong. That doesn't mean you win your case. Then we use the other impairments to carve out, potentially other things. CG says no initial. Where do we leave off, CG? Oh, denied on initial. Yeah. You know what? Just appeal. You will soon be over 50. And if you've gotten your grid criteria met, big if, because it's still pretty arduous to show that you cannot do more than sedentary work, then, you do have it a little bit easier come December. And again, if they're ever going to do that borderline age, potentially before December, but I just made a third cup of coffee. But that's because I have a late night tonight, right? Hanging out with my friend Jonathan. For Lent, which I've never really done anything seriously for Lent my whole life, I eliminated sweetener from my coffee. That's pretty big, don't you think? Once I drink coffee. So this is full cream, a little bit like a teaspoon, in regular coffee. And someone taught me that if you put a pinch of baking soda in it, it eliminates a lot of the acidity too. So I do that too. But yeah, I'm getting used to it. I'm like, 40 days of that, and I probably never have to go back to sugar. It's not like dessert anymore, granted, but I don't really need to have dessert. I should be more picky about my desserts. But I figure, well, that's a lot of sugar I'm eliminating from my daily diet, just by eliminating it from my coffee. I was using honey. Back in the day, I used to use all the artificial stuff. Horrible, right? Hey, My Cross Ministries in the house. Hey there. Hey there. And in the end, My Cross is saying hello to everyone in the chat. So CG saying has to appeal, but need to request my file RFC to see what it was. That's true. So I hope you already requested that with a 3288. And then follow up. I would follow up. Maybe wait a week and then keep following up and be a little bit of a sweet nag to them. And just say, I really need it. And it's program purposes. I need to know to appeal, how I'm going to appeal, what I'm appealing. What am I appealing? What do they find that I know is completely wrong? Because clearly it's completely wrong. Pardon me, guys. Yeah, CG's pointing out that he's 49 right here. She is 49 right now. Got denied an initial. In 8 months or so, will be 50. And yes, the grids will start to apply. But there are a lot of 50 to 54-year-olds that still get denied. So you have a lot of work to do. So get it done. Use this time to really go to town on a type of medical treatment that will best help your case. And that's where it's very case specific. The generalities, and I get a lot of argument. I get pushback from clients sometimes like, but that's not my big problem. I'm like, I know, but that's the one that's going to help you win your case. It's not to stop the other treatment. It's just that you have to add this on. The treatment load got a little bit more. And or the follow-up or diagnostics. Twill's in the house. Hey, Twill. Watching from Mississippi. Hi, Miss Stephanie. Good evening, everyone. Good evening. You mean good afternoon, right, Twill? My goodness. Not evening yet. That'd be close. Unless you're abroad. Cannon says, pre-existing. Okay. So the blindness was pre-existing, but you were able to do that other job. I have to assume there's not many jobs that you would be able to do with that vision. Your vision, right? Oh, wait. I'm mixing you up with someone else, aren't I? Oh, no, I'm not. Okay. So you're already qualified for both SSI and SSDI. You said I qualified, so you won. Or you didn't win. Because what race is there to finish? I'm confused, Cannon. Totally confused. Okay, 3D says, in explanation, I appealed the ALJ decision on my own. Well, good for you, because the Appeals Council appeal is the easiest one you can do. Easiest. Because you don't have to add doctor, you don't have to add anything. You just appeal it. Yes, I want to appeal. You don't even have to put a narrative. And fortunately, the appeals council granted a review, which is awesome, and vacated the decision. Unfortunately, no one will take my claim even with the remand. Why is that, 3D? Why is that? Are you young? Did you tell me how old you were? Oh, let's see, my mind is like a sieve, guys. Can't keep everybody's demographics in I don't think you even told me, did you? It could be because of your age. Yeah. Oh. First of all, they filed a fee petition. They're not, well, maybe they can. I was going to say, you don't file a fee petition until the person has prevailed, because there is no fee to be had unless you prevail. I find that kind of cheesy, to file a fee petition on a case that hasn't won. It just, I don't know. And I will say, sometimes they don't, if you withdraw from a case, or, somehow you all part company, and it's true that I might not get wind of the fact that a case I worked on won, and I had a lot of participation in that. So I might not even get to do a fee petition. That could definitely happen, I think. They're so rare. I know the last one, which was probably like 3 or 4 years ago, I did get notice, and I sent in a fee petition, and I got paid. It's great. So I don't mean to make light of it, but it's like, it's hard to get a new lawyer when you have a withdrawn, or you terminated, or they terminated relationship with the prior one, because unless they waive fee, they're going to want part of the fee, and then the new lawyer, who might be doing a ton of work, particularly if they're getting it all ready for hearing, will definitely not get paid for every hour worked. I mean, they generally don't to begin with. So imagine that. So it is hard. It is hard to. I think a practice, if they're going to be an ongoing concern and worry about finances and keeping the lights on, they have to. That's one of our waitlisted areas. Is, it's always, well, I should say it's always full, not always waitlisted. I always say the word waitlisted, guys, because it's technically true. However, I'm always saying, but you can't wait. So you got to go. You need to keep looking. Don't wait for us, even though, you know what I mean? So yeah, it's a tough one. So sometimes when I see those, I'm always trying to find another avenue, because we have different categories. We have veterans, like there's other reasons why sometimes someone might be prioritized when it's a wait list. So, and I know that can be frustrating, probably, to those that don't have that kind of special thing about their, their case, but it's just something that we do. So let's see. Jeffrey Taylor's in the house. Hi, Jeffrey. Howdy from South Texas. Tiger Bite's in the house. Tiger Bite. Nice to see you. Is that Troy Cinema? Glad to see you. Twill. Glad on 9+ medications I'm on, and my cardiologist just added one for my heart. 49.5, awaiting ALJ hearing. Well, you might be in that borderline place. You know what I mean? Borderline age category by the time you get the hearing. That can be helpful. So Vivi's in the house and has a question. So let's go to this next question. She says, hello, good morning. Well, I said she, but it could be he. SSI Recon, mental health and physical case, 20s. All right, so Vivi is young, very young. 1% are here, yeah. I have a few cues, but I'll start with one. Writing a personal statement, how detailed in explaining limitations and gaps in treatment, 5+ pages. No one's going to read it, so I don't know why you're actually writing it. That would go in your function report. And those have limited spaces for a reason. If you have seriously bad problems, trust me, you could say them in like 10 words. Don't use flowery. No one wants to read your novel. They're working, they're busy, they're overburdened with, too many cases. So you want to just drive home the main points. I do think it's helpful if you have a reason for the gaps in treatment to explain that, and I would do that in one sentence, maybe in the remarks on the last page of the function report. I'm not kidding when I say I wouldn't be writing that whole long thing. And the judge isn't going to, well, technically he has to review everything, but it's what you testify to. Again, it's about the medical evidence, not about you winning them over with your wonderful prose, you know. Michael Dean's in the house. Hi, Michael. Who we meet? He says, hello, Joy. I'm 55 and applied for both mental and physical impairments. I had 2 consultative examinations on February 28th, and yesterday my portal said my medical decision had been pulled for FQR. Is this good? I tend to think it is. I, by and large, feel like it's more awards that get pulled than denials, although I have another interesting story that just happened recently that showed me up about that. But I always feel like it's a FQR when they're double checking to make sure that it wasn't awarded inappropriately, where you would just get it pulled from you later. So it's to make sure it's solid, that the examiner or the adjudicator was following the federal rules. Because remember, the adjudicator works for the state and is outsourced to the Fed. So they gotta understandably have to make sure that they're not mixing anything up, following the federal rules, the Social Security disability rules and regulations, etc., in terms of coming to a decision. So I don't get concerned when it's an FQR. And on the part that showed me something new a few weeks ago, had a denial on a young person's case. Vivi, I had a young person's case, and it was a denial, not unexpected because it was a young person. And before I even got the appeal out, he got a letter saying, we found you disabled. So somehow there was a review, and they flipped that denial into an award. It was an SSI only case. So that was kind of thrilling. I never even had to take the time to do the appeal. That was good. So that, and I assume it was an FQR. Stop barking. Vivi says, mental health and physical issue going on 4+ years. I'm sorry. It's you have a big mountain to climb. I'm sure you're aware. It's hard to reach that. Can't do any of those 12,000 jobs. The simplest, the easiest, the less stress, the no stress ones. Supposedly no stress. Screaming Eagle says, approved first time at 59 years old. Tell me it was highly unlikely I would get approved. Why? I asked him why. Oh, someone told you that. I asked him why, and he said most people just don't. I then said my evidence is very strong, and he said, so what? I don't know who you're talking about, but that's pretty funny. Well, it's true that I will say this, Screaming. Everyone says their evidence is very strong. And I'm like, oh, okay. They don't know what strong relative to what? The high bar of Social Security disability, or the low bar of getting your mom to make you cookies because she feels bad for you. You know what I mean? Like, it's how high is the bar for what's considered good? It depends on what the bar is, right? So it is a high bar, but at 59, you've got the benefits of the different rules in your favor. So I think there are people that are denied that aren't in their late 50s, even though they have strong evidence, because it's not quite strong enough to check off every checkbox with definitiveness that all jobs would be out, even a sit-down easy job would be gone to them. But by the time they get to hearing, particularly if they're properly advised, they can kind of get the evidence to fill in those gaps. We Always Watching is in the house. Nice to see you. We always. This is the next question. My DAC, that would be Disabled Adult Child, for anyone who doesn't know the acronym, was denied for technical, but my SSI is still in step 4, non-medical review, for 2 weeks now. What can this mean? Well, what do you mean by your DAC was denied for technical? I don't think it's for technical, but you'd have to explain why. Generally, it would be denied because you did not medically prove that you were disabled since before age 22 without interruption, without legal interruption of that disabled potential status going back to 22. So that is a medical thing. If what you mean by technical is, well, my medical condition never changed from 22 to the present, but I did work and make SGA for 2 years during that time. Even though I was part-time, I was making SGA. That would boot it out. So I understand if that's what you mean by technical, then technically that is technical in a way, because yes, it's saying you weren't disabled for those years, but it's not saying you weren't severely impaired. You just were not severely impaired enough not to make SGA, you know. And the reason why the SSI can still keep going is because the SSI doesn't care about what you did 2 years ago. If you were working SGA, that doesn't defeat SSI. It's what you're doing now. You follow? So that's why SSI is very easy in that regard. You can apply for it forever. You just got to be poor. Whereas the other ones have, like SSD, you have to have insured status. Your DLI cannot be in the past. Or if it is, you can only prove that you were disabled then on that old existing evidence, not on all the great evidence you're getting now. And of course, DAC has that. It better have continued, including the lack of earnings since you were 22, report. So I hope that maybe opens up some eyes to some of the questions there. We always. Mark Benson's in the house. Hello, Mark. Mark says, next question. I had my ALJ hearing a few weeks ago. I have been checking my direct deposit information on the Social Security website for about a week, and it says in red lettering, we cannot allow you access. Oh, yeah. Okay. I think it might be you guys could tell me, when you have a claim pending, you can't change your direct deposit information. Can't enter your banking information. You guys can let me know if that's so or not. And does it even allow you to put in banking information if you do not have a pending claim at all? You know what I'm saying? Might not. I know you can change your banking information after you've won and you're a beneficiary, but what about beforehand? I'm assuming they don't want to have your banking information if you don't even have a pending claim. And then they put it in the beginning. And then maybe they don't let you fudge with it until the whole, Yeah. So you got to wait for your decision. I know it's hard to wait for that judge decision, right? Sherry Romero's in the house. Sherry. Sherry says, so here's the next question. I was here last week. I have prescriptions for shower chair, cane, rollator, TENS unit, a shower cane, a shower chair, a cane, a rollator, a TENS unit. I have MDD with psychotic features. So that would be major depressive disorder with psychotic features, which almost makes me think like schizophrenia or something. I have support letters from my psychiatrist and PCP. Do you think a good chance? Well, it sounds like you have physical and mental, very severe. If you're treating vigorously for the MDD with psychotic features, if you're on antipsychotic medications, if you're still having, whatever makes it psychotic. Is it hallucinations? There are still ongoing. Are they having to change their meds a lot because it's not fully conquered yet by meds? So that would still, if it was, maybe you could do unskilled work. But you have some significant physical assistive devices there, Sherry, which suggests to me that you have got a lot of issues with standing safely, ambulation, that kind of thing. So the rest of the questioning would come down to your vocational profile. So, because it sounds like you have significant physical stuff that would maybe reduce you to a sedentary sit-down job, but depending on your age, you have to prove you can't do a sedentary sit-down job. So that's why that whole vocational profile details becomes important, including your age, most importantly. Age and the most recent job, if any. Okay. Tony P's in the house. Hi, Tony. Tony says, he's sharing that on top of my physical and mental, I now have mild cognitive disorder. That would be a mental. I'm already approved Will they be nicer on my CDR? Not so picky. CDR is nicer, I think, because the burden is more on them than on you. So treat for the mild cognitive disorder. Keep following up with it. Maybe get tests to show. It really depends on what you're, again, you might have already, because you already had the mental in there, you might have already established that you can do no more than unskilled work. And if that's the case, additional mild cognitive disorder isn't going to really change that. You've already gotten the best outcome you can get with that, by and large. So showing that it continues and is not improved, which if you have a new diagnosis, it probably would help with that. And keep it on top of your physical, because that's going to be very, very important. Very, very, very important. Michael Dean says, ooh, a little share. I'd like to remind people that it is very likely that you qualify for Medicaid if you live in an expansion state. I had no idea I was eligible and got approved for it today. Yeah, most poor people, no matter where you are, Medicaid is for the poor. The expansion included things like you don't have to be poor to get it in some states. So basically, some of the rich people are getting Medicaid because of that. Just saying. Sherry's 30. So you're young, Sherry. Yeah, you got a lot on your plate. But that physical stuff that you described seems very acute. So if that's chronic and not just, well, for a few months because I was in a car accident and I have to use a walker, you know, that if it's chronic, it does seem to be strong, but will it all get you so you can't do a sedentary job? That's the question. Michael Dean says, I'm sorry, it's a little warm in here. Michael Dean says, I went over a year not knowing I could have had Medicaid coverage. I get a lot of people, Michael, who are like, I don't have it when they start with me, or when they're like, we're doing intake and I'm deciding and we're talking about whether I should represent them. A lot of times they say that, and I'm like, let's say it's a Monday. I'm like, I expect you to apply for Medicaid this week. Just do it. It could take a number of weeks for it to kick in. If you have wherewithal yourself, you might not win it, but then you've got to use your own money to pay for your health needs, So there's different ways to skin that cat. But yeah, I definitely think if somebody does not have insurance and they don't have a working spouse, and sometimes, with working spouses, even though they have enough money to get by, they can still get some Medicaid, like you said, in some of those, some or all of the states. And then we have some of the states that just went a little overboard, just to, like, I don't know, broke out their working people and, give some wealthy people who don't work some free medical coverage. Yeah, that stinks, Michael, a whole year. I'm glad you got it now. It's really important. And it's important in a way that, just for the purpose of this, you can't win your case without medical, robust medical evidence. And if you don't have insurance and you're not working, most of the time you can't afford to go get that robust stuff. So we've even had discussions, Michael, about people who are disabled from working full time, but they could do something part time. Sometimes they go and get a part time job under SGA. We still fight their case, so they have $500 a month for which to pay for an insurance policy that will cover what they need. It's the basics, So it's, like I said, many ways to skin the cat. People got to get creative and realize, sometimes you have to think outside the box. And once they learn that things are not going to be handed to them easily, to the things that they can do, that they're going to get a lot further. So, but if you don't know that Medicaid might be available, and I've seen that a lot. So if nothing else, at least we got them on Medicaid. You know what I mean? Or got them to apply for Medicaid. All right. Chill Nichols in the house. Oh, Chill Nick. 1865. Nice to meet you, Chill. Chill says, I have my first meeting with my SSDI attorney this week. The office paralegals told me that the attorney will be taking my case, but the meeting is to sign paperwork and for me to meet the attorney. Well, that's sweet. Seems like a pain in the arse, but, they might not be very up on tech, so maybe they, sometimes, like, the firms that have been doing other forms of legal for a gazillion years, like when I started back in the Stone Age, they haven't really gotten a little more modernized, you know, and they make their clients drive down there and all that business. I would say most of the SSD attorneys that do it full time don't do that, but you know, I do enjoy meeting them. I'm curious if they make you wait in the waiting room, or like, will they be timely? Just curious. Chilnick says, any tips on paperwork or info I should bring for the attorney? Nope. What kind of questions might the attorney ask me? You'll have to ask him. And what should I be asking the attorney? Any advice is appreciated. You know, I think what might be helpful to know is expectations of communication. Does he have a portal where you can message him? Obviously, you're not going to be able to call him up and expect him to be able to take a phone call with you. Those are really more scheduled things for needed items. But do they have a portal where you can send a message if you have a question? Or you can upload paperwork securely to a portal when you get something in that they might find helpful. Yeah, so if they want to send you a message, can they send you a message to the portal? And that's your go-to. I think a portal can be so helpful. It helps staff answer quick questions that you might have, you know, while the attorney's busy doing court or for hearing or whatever. Simple questions that knowledgeable staff can answer. Why should you wait, you know, a week or two for the attorney to free up to be able to get to that inbox question, you know, when he's busy doing hearings or whatever that take precedence, when your answer could have been handled by, you know, a sharp paralegal or, you know, disability associate. So the portals are great. You can like message them at any time of day when a thought comes into your head. You don't have to, you know, be prepared. You don't have to think about what you're going to say. You can pre-write it however you want or not, you know, like it's really helpful. There's also, I know with our portal, there's texting capabilities. So you can use your phone. You can use your phone to get into the portal too, but you can use the phone to text the portal texting number. And then we can text you back and it'll go to your phone and you won't have to log into the portal. Those are for usually quicker things that we want really fast, like pieces of information. You might want to also ask them if they assist you with the function report. Like, do they prepare it after you give them the basic information so that they can make sure everything's kosher and worded the right way and accurate and not unresponsive? Do they assist with those things? Or do they have you just do it, wing it, and send it in yourself? Sorry, my hair's going on my face again. Those might be questions, because those are the things that people seem to care about. Those answers, you know. So how I guess robust or in-depth is the firm with regard to embracing all the things that, you know, are helpful for SSD cases to move along and clients to be addressed and all that. PCWC says, hello and hi, welcome to see you. Hello, is there any information about the SSI Restoration Act? You'd have to describe for me what that is. I don't even know what that is. Is that a slang for something, or is that some bill that someone's putting up that'll never pass, or is it something big? SSI Restoration. And we have SSI, so what are we restoring? Hey, Thomas Harris is in the house. Hey, buddy. Hope you're doing well. I'm doing very well. How are you doing now? More importantly. Sherry Romero says, I have neuropathy in hands and feet, cervical and lumbar radiculopathy, and memory loss documented by my doctor. You know, Sherry, depending on how much you need the rollator, do you mean like a rolling walker? That uses two hands, so you can't even be walking in a sedentary job to bring papers to somebody or whatever. Do you still have a fall risk with that? There are some times where when you need too much assistance to walk, even if you're otherwise able to do a sedentary job, say unskilled due to that memory loss, that the instability on the feet won't even accommodate the up to 2 hours you still have to kind of get around the office for a sedentary job for most of them. So you're young, but you have a lot of bad stuff. And I'm really sorry. I mean, you're too young to be dealing with that. Life is not fair, I know. So hopefully you're keeping up your spirits and your chin up and you have a greater thing to focus on. But your stuff is pretty significant. And make sure that you are treating for all of those all the time. Probably Medicare, Medicaid, right? Are you seeing therapy for the memory loss? You're getting memory therapies, occupational therapies for that. Do you need, I forget what the other mental impairments were. Oh, did you say the psychotic traits? Then you must be having a psychiatrist, medications, and a talk therapist weekly. Those are things I would jump on. And neurologist for all the other things, with very regular updates to diagnostics to see how that back is doing and the radiculopathy. Yeah, I mean, you've got a lot going on, girl. I feel for you. What you go? Vivi says, I'm confident I can't do full or part-time work because my symptoms are unmanageable for consistency such as that, but wanted to see if I could handle something occasional one day a week. Okay. So let's say you found a job that allowed you that flexibility. You could pick whatever day. You had 8 hours you had to get done, however way you want to cut and slice it. What is that doing? That would be a job that doesn't exist in substantial numbers probably, but you could still earn money from it if you need the money for something. And it also helps you potentially, if you make at least, $2,000 a year, generally, you're going to earn at least 1 credit. If you can earn more than that, better, because you can keep pushing your DLI out forever, and you can keep fighting your case. If you don't win, you can file again for SSD. SSI, you don't really have to worry with that. And SSI, of course, every dollar you brought in is going to some degree, take away from SSI. So should you prevail? Red flag for the SSA? No, but they will inquire about it. And they need to know all about it. What kind of work are you doing? Is it going to be inconsistent with what you say you can and cannot do? Is it SGI? Is it not SGI? So it's definitely relevant and material, but I wouldn't call it a red flag. A lot of people work part-time with disability, and it's not discouraged. And it's not a reason to lose your benefits either if you do it right. So I would expect that you would do your due diligence to get proper information on it if you do it, okay? Sherry said, I've had these for 3 years and it just keeps getting worse. I applied in 2023. Yeah. Are you still in the same case, or did you reapply? Are you doing SSI or SSD or both? Eventually, you'll run out of SSD. You won't be insured anymore if you still are. Ray D says, at a remand hearing after the appeals council finds legal error, does the ALJ usually look at the case differently than the first time? Also, I am in my late 20s. My claim has been ongoing since 2023. Okay, does he look at the case differently? I believe so, because it's going to be the same judge probably, and he's already been kind of smacked down, saying you screwed something up. It's kind of a professional blow, I think. So he's going to make sure not to do that legal error again, by and large. And it is your opportunity to really vamp up your medical evidence by robust treatment, follow-up, getting new diagnostics if it's diagnostic-oriented, vigorous treatment, vigorous pursuits, conservative therapies, physical therapy that shows that this is still going on. That can be really helpful at a second hearing, because I've said this before, giving the judge new evidence in addition to what he had before can help him potentially, I'm just trying to think like a shrink now, in his mind, be like, oh, now that we have this evidence, now I can find him disabled. He doesn't even have to say, yeah, I screwed up and I wouldn't have found him disabled if I had followed the rules properly. He didn't have to say that, to himself, or, he could just be like, well, with this new evidence, it gives him food to think about awarding, and not having to be like, I made a mistake before. No, I didn't make a mistake before. On that evidence, I still would have denied. But now that I have this, particularly if there was some missing from your old hearing, 3D, like, was there something not in front of the judge? If you can get that in front of him, then you might even get an award back to the original date you wanted it. Otherwise, sometimes a remanded judge might win you, they might deny you too, but might win you with a later date than what you've said. Now that you have the new evidence in, at least he can get you there, you know, so just different things that can happen. This is really annoying. Annoying. All right. You're welcome, Shell. Thomas says, doing well. Nice to see your smiling face, and thank you. PC says, SSI Restoration Act is a bill in Congress, there's like 5 million of them, that the Senate in talks with. I hear it has a few support. Well, what is it about? I'll have to look it up. Want me to do a video on it? If it's interesting, I will. If it's a foo-foo, nothing, I won't, but I wonder what it is. SSI. So remember, that's supplemental security income. You're saying it's about the welfare program. It's not about Social Security. If you have your name right. Shiloh, what does SSA consider regular treatment for mental health? I would say a consistent schedule. There's regular treatment, which for some people that's once a week, some people it's twice a week, some people it's once every 2 weeks. That's not that unusual when they've been going for a long time. Sometimes it's once a month, sometimes it's once a quarter. I would say the less frequent, the better off you are in terms of your health, because you don't think you need it more robustly than that. So I think frequency can really speak to your own. It kind of represents how bad you think you are. So if you don't think you're bad enough to need weekly therapy, why should anybody else? You know? But regular means, I think, it's not like you're just one-offing, just every 2 years you pop into a therapist or you go to a psychiatrist or something like that. Twill says, so this is kind of a next question. That was one of my questions about mobility. I have a rollator with a seat along with a quad cane and a knee brace. I think I remember this from last week, right? Diagnosed with Meniere's disease, carpal tunnel. Of course, well, I guess the Meniere's might be why you have the rollator seat, right? 3 mental diagnoses and a leg injury. Oh, the leg injury, yeah. Yeah, the rollator, again, if you don't need it very often, it's less, it's less of a big chunk, but, it's like a walker, 2 hands. That means you can't be carrying something, even if you need a cane. Like a cane, sometimes they'll be like, he can do a sedentary work, because sometimes they'll even ask, can the person walk and hold a piece of, an envelope in one hand while working with the cane? And they'll ask the consultative examiner that. So that if a person's with a cane, they get the answer that, yeah, he could still do that. It's a little different if a person needs a cane for standing stability, not just for walking, then they're one-handed even when they're at a desk or a table doing table work, because it's a table work proposed job by a CE, because now they need the one hand to stay stable while they're standing there supposedly doing a 2-handed job. It eliminates 2-handed jobs if they need it for standing. Charlotte, I know you asked this question in a different way. I think I answered it. New way to ask it was, what does SSA consider regular treatments? Meaning how many mental health visits yearly? It's not really yearly. What if you just started 6 months ago? It's not going to be a whole year. So it's really more of that regular, I go weekly. Every 2 weeks I go to I have my therapy, that kind of thing. We are at 1 hour and 35 minutes, guys. So we got about 25 minutes left. 12 says, medical records state I need the rollator walker for short and long distances. Also, my mental meds are pretty strong with side effects. Oh, yeah. Quetiapine. That's definitely antipsychotic. So, right? Antipsychotic? Psychotropic. Be sure to document to your doctors the side effects, I would say, too. Both the physical and the cognitive you have. So Trill is going for vestibular therapy and physical therapy 4 days a week. Hey, Shub is in the house. I'm glad you're getting on that therapy, 12. Hey, Shub. Nice to see you visiting. It's very nice when successful claimants come back and visit. We like that. It can be a bit of positivity for everybody else along this journey. Vivi says, okay, I see. And this is a question here. Is the attempting work situation different for SSI? Not in terms of finding whether you're disabled or not. But when they go back, if they do find you disabled, and if they go back and see what do they owe you for all those past months, they're going to have to subtract out what you made that month. You know, $1 for every $2 you earned comes up top. So you never want to earn more than that would take out all of the SSI, which is a really hard thing to do because you're going to be way over SGA too. So, and you don't want to be over either one of them. I'm in my reconsideration in my 20s with mental health and physical problems, something occasional such as babysitting, for example. Yeah, is that so you can try to, I mean, sometimes people just babysit to babysit. Are you trying to earn money? Are you trying to earn credits? In which case, earn the money and then pay the taxes on it at tax time? Which there are SSD reasons for doing that, which we've talked a lot about. Thomas Harris says, oh, that's really sweet. Stephanie and her team helped me get my disability the first time. You guys are in good hands. Yeah, that worked out perfectly. Sherry Romero says, SSI and SSDI, I had worked part-time. I had worked part-time being my mom's provider for 3 years a day, spaced out all day, and I had 35 surgeries since I was born. Oh, I'm sorry, Sherry. I was on SSI until 18. I had to stop because couldn't do it. Had to stop what? Being your mom's provider, or had to stop SSI? I will say that, well, there's so much to your case, Sherry. It's kind of hard to get into it here. Yeah. Like, did you stop the caring for your mom 3 hours a day because you couldn't do it? Did it put you over SSA? Is that why you lost your SSI? Why did you lose your SSI when you turned 18? Because they judged you on a, just so you know, guys, when you're on SSI as a child, you get redetermined at 18 because the definition of being disabled as a child is obviously different from the definition when we're an adult. Because adult, it's about work, and child, it's not. So they have to reassess kind of redetermination at 18 to see if the person is disabled under the rules for disability as an adult. And that sometimes causes people to lose the redetermination. Mephisto says, does the SSA DDS doctor take your age into account when assigning an RFC? Very loaded question. Let me tell you why I think so. First, the RFC is not supposed to be age-related at all. Those are what the laws do, right? However, many of us on this side of the fence would swear that a doctor working for the SSA does take it into consideration, because when they seem to be making it a stretch to assign a 54-year-old to an RFC of lights, knowing full well that light will destroy their case, instead of saying, yeah, he probably can't do more than a sedentary job. You just have to think that it's because it'll get the denial. We've just seen it stretched where we're like, come on, you know the person can't do light work. That's on his feet 6 out of 8 hours. He's got triple surgeries on his lumbar spine. You know, just so officially they're not supposed to. Have they always? It seems to me they always have. And I feel like about 5 years ago, they really stepped it up. So that's what I feel like. Yeah, Vivi's trying to earn something of an income if I can handle the amount of occasional work. Yeah, you know, some people do gigger work, or they you know, figure out their own self-employment, like you said, like babysitting. Obviously not someone that it would be contrary to what you say you can and cannot do. So if you can't lift things, I wouldn't be babysitting for a baby or a toddler. Sometimes it's house sitting. You know, it's a little bit of occasional. It's usually not highly regular. But, and then if your goal is to get SSDI insured status or keep it from expiring, then you want to not write off everything as a business expense from the self-employed business, which it all is when we do this, and just declare the whole income and pay the taxes on it, meaning the self-employment taxes, because that is your Social Security taxes. I have to pay mine soon. As a self-employed person, I pay the employer side for myself, and I pay my own. It's a lot. That right there is like 15% of your every dollar, on top of your federal income tax, your state income tax, and your local income tax, which we have all of the above where I live. You just get you coming and going, right, guys? La Rocho's in the house. Hi, La Rocho. Good to see you again this week. Hey, Stephanie. Next question. I am here late again. No worries. I promise to watch your entire program. Don't want to miss everything. SS was Stephanie. Oh, you're sweet. By the way, I got the call from the hearings office about canceling. Oh, refresh me on that. Were you going to cancel your... Were you going to withdraw your request for hearing? Is that what we were talking about? Sorry. I talk about these issues with multiple people every week. So I'm like, which one is it? All right. Shub shares with us. I'm 57 with a 5 to 7 year diary date. If I had surgeries on both knees by then, are they really going to make me go back to commercial driving? Remember, they're not going to make you go back to commercial driving, and they don't even have to. I don't think it's going to happen to you, Shub. So I'm just saying this generally for everybody. You don't lose a CDR because they have to find that you could do your old job. They just have to find you could do any job that exists in substantial numbers. So, and usually they make sure it's three jobs they usually list. Yeah, I think it's unlikely. But just so people know, you don't have to just say, well, I can't do my old job. They're never going to think I can, so I'm safe. Because even if that's true, do you improve enough to do other jobs? You know, that light job or that, you know. But again, if you had commercial driving and they can't prove that you're improved enough to do medium level work, which I would hope at like 60, they're not going to say you can, not with the, you know, surgeries and such. So you're probably in good shape, Shub. Don't you think so? I think you agree with me, right? Twill says, why is it not clicking on? If my husband and I file our taxes jointly, but my income is 0, will that send a red flag that I'm over SGA? No, it's what's under your Social Security number. So that's why it's really important if someone is working, they don't let it all go under a family business. Like, let's say the husband or the wife is always putting all in their name, but the other person's doing all the office work and customer service or whatever. That's a big mistake people make. Huge mistake. Putting it all on one person's Social Security. Maybe they're going to get it. I don't know. Maybe their accountant said it's going to be cheaper to file your tax returns. I don't know. But now the person who's also working and could have been earning Social Security disability insurance would have been paid for. Now they don't have it. So no, joint tax it doesn't show up under your Social Security. Only what came under that W-2 for him or 1099 for him will show up that way. So no worries. It gets kind of like diverted out to the right people when it comes down the pipe. And you'll know this, 12, if you look at your annual Social Security earnings statement. There will be a 0 for you. Okay. So as long as no one puts you on a Schedule C saying you're, doing self-employed work and you're not getting a W-2 or a 1099 in your Social Security number, you'll be fine. La Rocho has May's hearing. Oh, right. Because you have, you had a surgery, right? Right? So the judge did agree. Now what? Were you the one that said the judge, they won't let me, maybe that was someone else last week. They won't let me change my hearing, even though it's like 3 weeks before this major surgery. And it's in person. It was in person. I'm like, that's crazy. Why can't they just change it to MS Teams and you can still do it from the comfort of your own home, sitting on the toilet if you have to with your phone, PCW says, I'm sorry, it's about giving people to have their benefits raised. Oh, is that the law you're talking about? Giving people to have their benefits raised to the federal poverty level. I think SSI is actually at the federal poverty level. I think. Is the federal benefit rate, which is SSI, same as the federal poverty level? No, I guess it's not. Increase the allowable assets from. Oh, okay. I actually support that too. Actually, yeah, that's been. But just so you know, like I know, it sounds like a big deal that it's a bill. We've been seeing this forever. As long as I've been practicing this, which is, I'm in my 3rd decade now, it's always been sought after. One of the reasons being the allowable assets, at the very least, there should be a COLA attached to that. That amount of $2,000 has been around for 40 years. Oh, if you can have up to $2,000. Well, 40 years ago, that was a lot more money. So that's, I just think COLA needs to be applied to anything that you think is if it's necessary at all, you know, there should be a COLA. Oops. I do agree with that, because I think if you did the COLA, it probably would be close to $10,000 now. If they had done it all along, might be a little less, but that's okay. COLAs don't really reflect the actual increase in prices to begin with, so I support it. There's been so many though, I don't really much pay attention to it now. I do not believe in getting rid of all in-kind support. At least I don't think I do. Let's see. You know, the reason being too, PC, it is welfare, and it's coming off the backs of low income and middle income people. So when you start allowing so much, it starts to be that the people getting the welfare have more wherewithal than the people working and paying their wherewithal. Do you follow what I'm saying? So I'm not saying that wouldn't be a good idea. I'd have to see the numbers. I'm a numbers person, and no one's showed them to me because it's not really what I do for a living, just looking at but when I see someone who isn't working, isn't able, or chooses not to, whichever, getting more than the person who does work full-time, it sits wrong with me, because the person that's working full-time but can't even earn a savings of their own, can't even get to that $10,000 savings, because they keep paying these taxes. You know what I mean? So that's where I come from. Not because I think that amount is high or anything, but it is a freebie. It is a handout, and sometimes it's on the back of someone who can't even save $2,000. I mean, I remember being that person where I could not pay my bills, keep a roof over my head, not put myself on welfare, and I couldn't save what they can save. So you just got to know it's not coming from a mean-spirited place. It's just saying, but what about the slave worker that's providing that? And they're not allowed to get that high. So that's just where I get my little, it's probably the conservative part of me, but it's, the workers, you got to think about them. Just got to think about them. Natasha's in the house. Hi, Natasha Johnson. Nice to see you. If you are only applying for SSDI, why do they submit for both? They don't. I'll tell you in a minute. If you already know that you don't qualify for SSI, what happens when they process your application? They don't automatically make an SSDI application and SSI application. You either had to say you wanted it, or you clicked the wrong button when you did your online thing that says, yes, I want to apply for that. That said, the opposite is not true. If you apply for SSI, they are obligated to see if you are eligible for SSDI on the date you allege you became disabled. And that is because SSI is welfare, and they need to know if you have other sources of income that should be applied for to prevent you from having to take from that SSI trough, if you will, what we were just talking about before, because you have other wherewithal. So if you have SSDI, should you be getting SSI off your neighbor, basically? So whereas SSDI is something you earned, you worked for, it's insurance you bought and you're insured for because you chose to do that. Well, you chose to work, Otherwise, the taxation for the insurance is compulsory. We've talked about that too. I think Jen, me, and I touched on that last week. So yeah, you might have that backwards, or someone clicked the wrong button. It could be if you did it online. I'm sorry, on the phone, which I never recommend. If you cannot do that, I wouldn't. And they automatically clicked it. They could have just accidentally done it, the intaker, you know. But otherwise, if you file for just SSDI, there is going to be no SSI file for, unless you proactively do it. And you have to wet sign the documentation and or attest by phone that you did so. That's how they help prevent fraud. Okay, so I hope that clears that up. What were we talking about, LaRoche? What would be an upgrade for the lower to middle class folks? What, LaRoche? You talking about the PCW's proposed SSI restoration? No, it won't. That would cause you more taxes to pay for it. I don't know where you're getting that from. No, you're totally mistaken. Lower to middle class folks don't have SSI. You see? The zero, the very low income can have a little bit. Remember, income counts against SSI. So once you get over a certain bare minimum of income, you dollar for dollar, it's, you know, $1 for every two if it's earned, dollar for dollar if it's not earned, like it's gifted. So I don't know if you guys are actually thinking about it fully the right way. LaRoche, it will increase taxes for the lower and middle class. PCW, I do agree with you on the numbers, should be raised. So I do support that. Not sure about the in-kind thing. We've already affected the in-kind thing greatly when they, what do I want to say? I almost want to say equalized. If you are paying the 1/3, like 1/3 of the federal benefit rate, that's the presumed market value for whatever housing you're getting, even if the landlord would normally be getting $10,000 for that, but you're paying $400 or $334 it was last year, then they're not going to dock you the 1/3. That was a big move, and I think it benefits SSI people. They're not getting docked 1/3 if they're at least paying that 1/3. It used to be they'd be getting docked if they were paying something less. Now it's not so anymore. But I'd have to really feel out all the other in-kind stuff and see where that could slide sideways. Because a lot of time there's unforeseen consequences of what you're saying. And then there's all these, as a result, then there's a lot of scammy, untoward things that we didn't realize would be going on. And that's the only thing I would like to see more on. But with regard to the rest of it, increasing the allowed asset from 2,000 to 10,000, I would totally support that. And what was the other thing? Wasn't there something else? Yeah, I think you were saying the benefit rate itself should be increased. And I don't even disagree with you on that, because even though that does get raised by COLA every year, COLA does not really, it doesn't really reflect the increase in prices. We know that. It doesn't do it when it affects Social Security benefits for retirees and disabled people. It doesn't accurately reflect the basket of goods we need, largely probably because of housing. Probably also because of energy, which is why it's so very important. We get off this, yes, let's be dependent on every other country for our energy. Meanwhile, we have more energy than they have here. We just, I don't know, laws of recent years refuse to let it go forward. And that's energy increases the food prices and the housing prices. Those are the big things. So I would, that COLA, it doesn't reflect that stuff very well, for sure. Okay, Vivi says, if SSA most likely won't read a personal statement, do they read third-party statements? It's not that they don't read them. How much are you, if you have to read 5 million pages a day, going to read Vivi's extra 5 typed single-space pages she decides to send you when you gave her a form to explain things on? Think about it. Think about the attention span you're going to get. Everything you said in that 5 pages, Vivi, I swear to goodness you could do in the function report. If you know how. If you don't, maybe get someone to help you. But it's true. And about the third-party statements, we've all heard this before. Function report is hugely important because it can sink your ship. It's not going to win your ship. It's not going to win your case, but because you have to answer it and it can sink your ship, you need to know what you're doing when you do the function report. Third-party statements, we often say it's just like useless, but if they ask for it, you want to give it and then make sure also it's not going to sink the ship. I think sometimes they're sent out to see if they will sink the ship. Because then you've got a way of, the person pretty much just said they're not disabled in their function report. Third-party statement, the reason why I say that's even far less valuable, but again, don't let it sink your ship, is you'll see in ALJ opinions all the time. Yeah, the statement by the spouse, I've read that I've taken into consideration, but I've also taken into consideration the fact that it's coming from a family member who would be, in so many words, biased towards the loved one. They're not completely unconflicted in the whole thing. So kind of the obvious, right? But you want to put the bang for your buck in where they're going to be appreciating it most, and that's your function report. All right. I know I could tell you're dying to give me your diary, but I'm just saying that there's a reason why they ask for specific questions and specific information, because it addresses the things that are relevant under the law to whether you're disabled. Your feelings and the long drawn out way of describing things isn't necessarily going to do that. It's going to be redundant and or irrelevant, because everything about your symptoms can be said in the function report. Yes, they can. I promise. We do it every day. Sherry says, I can't remember the precise reason why it stopped at 18. It was probably because you didn't meet the 18 and above rules. But I didn't start working for my mom until after we got back from Tennessee, because I also had cancer at that time. Oh my goodness, girl. At the time, I know it's a lot, but thanks. Yeah. Are you represented, Sherry? I know you're young, so you might have had trouble. If you want to fill out our eval, it's on I think it's scrolling across the bottom where you go for it. Tell them somewhere in there, put that we spoke online. Let me see where your details fit in to see if there might be an opening, particularly if I can pull you out of one that would be closed and into another based on certain things that we see. So I invite you to do that. I personally invite you to do that. I feel for what you've been through, and I really feel for the young people who didn't get to have the life of 50 years that many of us got before we went downhill. They haven't had that blessing or that fortune. They've been blessed in other ways, I'm sure, but it's the same opportunities just didn't exist, and the same comfort in living and all that. And it is pouring out there now. Woo-hoo. I guess I can't do that yard work when I get off with you guys. Yeah, I'm so upset. Cleaning up all that dog poop and stuff. Okay. LaRocho says, Stephanie, reference hearings office canceled my, yeah, and I'm still waiting my application to release 2012 on my credits. Remote DLI and in 2020 for widows. Okay, that was a different cancellation. They were canceling it for some reason. You didn't know why, right? That's really frustrating. You'd think it'd be nice if they had like another lawyer that could, not a lawyer, another judge that could step in and take ones that they know. Like, let's say the judge has to go have surgery and he can't do it that day. I mean, understandable reasons, right? Is there somebody else that, like a pool of other judges where they take them in, maybe change the time, maybe it's a day off, something, but like in the same time frame. That would be nice. And I think we might have touched on this other LaRocho. You can also waive the 75-day notice for the new hearing. I think it might already be that if you've already been scheduled for a hearing, they don't have to give you the 75 days. But if not, you can try to waive it yourself anyway. LaRocho says, that wasn't me. No, thank God. No surgery. Oh, they canceled, no rescheduling. Okay. Vivi says, it's 3 o'clock, guys. I've been going 2 hours. Should the third-party statements of people who know my daily limitations be written? Or do they fill out the form SSA provides? Does it matter? Well, the SSA is going to send a 3380, the third-party function report, to the person you put down when they ask you for a contact. And you put someone down, and that's who's going to get the 3380. They actually gave you an opportunity now with the online application to mention 2 contacts, which was a newer thing the last year or 2. So they will send the 3380, and your people will have to answer them then anyway. And if they already sent it a statement and then they have to do the 3380 and they forget what they said in the other statement, they might answer inconsistently. Do you want to risk that? I would wait till they get the 3380. Now, if there's a third-party statement from, this would be different, Vivi. Let's say you have an employer, a former supervisor or coworker who, and I don't know your situation, but saw the severe struggles you were having with growing impairments on the job. That is something that I think can be useful because it's kind of coming from an unbiased person, like a supervisor, just an employer or a coworker who probably isn't going to be willing to BS a federal agency, and they're just describing what they saw on the job. It could be, pain observations. Maybe you had to take a lot of breaks and go to the bathroom. You called out sick a lot, had to leave sometimes early because your back would seize up. I don't know what the situation is. Or let's say it's mental health stuff and you were multiple times a week running to the bathroom crying. Like the stress of even that basic job would get to you, whatever. But whatever they saw, that can be helpful. That is not always easy to get. People don't always maintain relationships with people they used to work with. But I find those to be really worthwhile when they exist. They don't usually exist, but when they do, very helpful. So I hope that helps a little bit. And remember, these are my opinions on best practices, guys. Other lawyers and non-attorney reps can differ. These are mine. They worked exceptionally well as we built this from 0 to what it is today, and with the rates we have. So, but definitely reasonable minds can differ. So just take it for what it's worth. And you don't I will not be offended at anybody not, embracing something I said, for sure. Now, my clients, on the other hand, don't have a good reason if they don't do it. One of a kind is in the house. Hello, one of a kind. Type 1 diabetic with A1C at 7.8. Ouch. Which doctor will not touch my back? It's too high. Any chance for a claim? Certainly for a claim. It sounds like you have a bad back, aside from the type 1 diabetes, because a lot of people can work with type 1 diabetes. But I'm curious about the type 1 diabetes and the high A1C. Do you have all sorts of symptoms related to that? How are your limbs, fingers, toes? Do you have wounds? Do you have syncope, or, do you get out of whack where it's dangerous to even be in a light job because you need to be sitting down because things can go a little, fluffy in the head? Those are the things I would be asking about. And of course, any other impairments you might have. Chance for a claim? Yes, the question is it a chance for a good claim? Right? Possibly. Siren's in the house. Hi, Siren. Do denials take longer than approvals? Probably not. But there is always kind of a myth that they do, that if you wait a long time, it's more apt to be a denial. And I guess it's because they know it's probably going to be appealed and they want to make sure it's ironclad written, following all the rules. So that's just like speculation. That's not necessarily true. Do I lean that way? I probably, maybe a little bit. I don't know. But I've gotten denials really fast too. So, and if I'm talking about ALJ denials, by the way, not down below. Oh, yeah, that's true. SSI, not SSDI. Okay, I'm not sure what that was in response to. PC says, I understand where you're coming from. No worries. Again, just a proposal. Yeah, no, for sure. And I love talking about this stuff. I'm not sure we should do it too long here, but you know, I'm a big debater, and I do a lot of white paper work on different issues for certain entities. So it's always like, I just always think you have to look at all the different angles. It's just why debating is so good. You get to hear the other person's reasoning. And then if you say, yeah, but you're not thinking of this, or vice versa, I mean, it's how we all can sometimes switch our minds because we hear something that we didn't think of before and no one else had said it. And then it can really make everything more clear, because if you don't see all the parts, you can hardly have the clearest of, interpretation. Severance says, if you are approved for SSDI, will you automatically receive Medicaid? No. You will automatically receive Medicare after the waiting period if you're still on it. Because SSDI, the beauty of that, it comes with Medicare, which is, in most of our minds, way more favorable than Medicaid. Medicaid is going to be based on your income. Now, if you're approved for SSI, in most instances, that is enough proof to say you're disabled for the state that you're in, and it's enough proof to say you're poor enough in the state you're in. So some states automatically have it that if you get SSI, they're going to give you Medicaid. And I kind of appreciate that because, and if you don't get approved for SSI, you can still apply for Medicaid because you can still use their long route to try to prove. But I appreciate the ones that say SSI, all right, then automatically this person, because they save their own resources. Why should they reinvent the wheel discovering whether you're disabled when the SSA has already said you are, and the SSA is extremely arduous? I mean, if someone can win through the SSA, darn sure they should be able to win through the state. You follow? In terms of disability. And because the SSI money situation, income, assets is very carved in stone and clear coming from the, why not just embrace that too? Right? And that way that state doesn't have to spend more of its own valuable resources, which resources are always limited, whether it's money, labor, which costs money, redoing that finding to see if, well, let's see if you meet ours. We tweaked it a little bit. Like, why don't you just embrace that and save yourself the aggravation and your taxpayers' money, Just an opinion thought there. Sarah D's in the house. Hi, Sarah. I don't know that we've met. Would you say it's possible to appeal a hearing decision when the judge didn't take into account your extra breaks and days off from your FMLA work accommodations file? The judge listed 3 late jobs, I guess. Late said jobs. You mean late jobs. Those other light or they're sedentary. I could do, but she didn't take into account my extra breaks and days. Actually, what happened is she didn't find it credible that you needed those breaks. That's generally why she didn't have to address them, because she didn't find it to be so. That said, I would appeal. If you know that you can't do full-time work of any kind, you believe that to be true in your heart, I'd appeal. Don't ever, you went to a judge, you have to appeal to the appeals council. Whether you decide to appeal to the appeals or file a new claim will depend on your particular circumstances, whether you can file a new claim, whether you're willing to forego your, all this also depends on the strength of your legal case, which would be your vocational profile, along with all your medical records and how strongly they were. Ad nauseum, they have to be very, very, very strong and robust and continuous and durational and frequent. I always say your full-time job, but it's not 40 hours a week. And that's how we expect our clients to be. It's got to be your main priority, outside of getting your treatment. It's got to be right up there. So I hope that answers your question, Sarah. If you can appeal, you can consider doing that. If you can't file anew, you have no choice but to appeal to the appeals council, or else the thing dies forever. So that's some of the big major rules of thumb I could tell you without knowing the details of your case. Hey, Jen Mee's in the house. Hi, Stephanie. Hi, Jen. Just got here. It's interesting then what they read and don't read. It's clear that someone read every word of my therapist session notes. Well, that's medical evidence. So, and I think they technically have to review everything. Now, sometimes things are illegible. and they can't be held to know what's in an illegible document, right? But, you know, the rule is they have to consider all evidence submitted. But then the question is, well, do they have to give it certain weight? No, they do not. So that's where I think the confusion sometimes comes in. Yeah, I read that, and I gave it very little weight because, you know, and if they don't explain why for certain things that are very robust in the record, and they don't explain how they came to giving it no weight, or they don't explain what weight they gave it at all, that is an appealable issue oftentimes, because that's part of their job when they make the decision. Medication side effects, Sarah's talking about. Yep. Very important. We have some videos on that. Very important. Jen Me says, also, my lawyer the other day looked at my therapist's functional report from the past before I met these lawyers and said kind of to herself, oh, all severe. That's not good. I said, why? She said, oops, hold on. Oh my God, I'm sorry. My clicker's not working. She said, because then it looks like they're making it up. And I'm just like, or maybe like the situation is really bad. Yes, but your lawyer has a very, very good point. I mean, it depends on which aspects, of course, so I can't speak to your case specifically, but let's say it says, how can the person communicate? Severely impaired. Well, like for instance here, Jemmy, you are an excellent communicator. You're an excellent writer. You're very astute. You have a strong thought process. You know what I mean? So it really depends on what they said is severe. Like, let's say you could be agoraphobic. You could still be a fabulous writer and strong thinker, but if you can't leave the house, guess what? You can't go out and do any of those jobs that exist in substantial numbers in the national and regional economy, right? Agoraphobia is huge. It's hard to prove, but it's been done. And that's through that really. So really, everything is so specific, but your lawyer is not incorrect when she says that that's the way it can optically come out. Like, wow, that person's probably in a straitjacket right now, living in a closet, or because if everything is severe, that person couldn't even like pick up the phone or maybe even send an email if their communication skills were severely impaired. No, because it's not going to ask on a mental or talking skills impaired. It's not going to be that. Or her in-person, it's not going to say that. So, I mean, I know what's on those forms, but you are correct in that in very rare cases, like your own, everything is severe. Now, everything on that list, you gotta. That's why I'm glad you have a lawyer, because they're kind of stepped away from it where you can't be, because you're living it every day of your life, and they can help try to, couch things in a way that is a little more maybe realistic optically for an adjudicator to look at. Gilmar Santos is in the house. Hi, Gilmar. Nice to meet you. I don't think we've met. Simon says, is it normal for your attorney to not meet with you after the hearing? When you say meet with you mean speak to you? Because most of us are, doing things over Zoom and MS Teams and all that. I know, like, I had a hearing yesterday, and when we're checking out with the judge, I'm like, he's like, okay, hearing over. I'm like, all right, so-and-so, I'll call you in like 2 minutes. And then we got off and we had a phone call and we discussed, what went on at the hearing, and still have to wait for decision and all that, but, all that kind of stuff. But I don't invite out for coffee or anything, if that's what you mean. I have my coffee with you guys. So I don't really know what you mean, because most of us who do this as robustly as I do, we don't do the coffee meeting, blah, blah. We don't even our clients are disabled, so we don't make them come to where we are. You know what I mean? We don't make them do any of that. We don't make them go to a hearing in person. There are other ways to do it, which are these days, the preferred way to do it. We do it kind of like the way the SSA does it. It's all kind of streamlined with how they work it, so this makes for smoother everything. Let's see, 3D. The financial stress during this process can be overwhelming. How do people usually manage that without jeopardizing their case while it's pending? Yeah, that could be a whole hour of discussion, right? One thing I always talk to my people about 3D, if I get the gist that they're going to need it, or if it's someone who comes to me and they're still working, but they're like thinking about filing because the work is getting so incredibly hard on people. Sometimes we have to, one of our, usually in that initial conversation is like, how are you going to get by? Do you have a spouse who earns an income? And can you downsize? Can you shrink your budget? Can you, getting rid of some frivolous spending, maybe not having Netflix and Hulu and just having one, or not having either. Everyone is so different. Some people have 401ks they can spend and rely on and survive on, which I hate that, because you want to have that for later, you don't want to have it. Some people will work part-time under SGA so they can have their case keep going while they're fighting the battle. So everyone is different in terms of what they need to do and what they're willing to do. Some people sell their house if it's big and they don't need a big house anymore because the kids are out of the house, and they go and they take their equity that they get from the sale and they buy a 2-bedroom little tiny place because they know with or without winning, their income's down. And being retired and not working, it's still down, right? I mean, you're living on fixed income. So everyone's got to try to there's probably counselors out there that, I don't know if they're pro bono, but, give ideas like, have you considered doing this? Can you do this? Da-da-da. I think that would be something to look into. Think about it on your own, of course. You can think about what you can. I mean, there's budgeting courses out there too. There's also, Dave Ramsey. Everyone knows Dave Ramsey, right? I mean, what a rock star in terms of people getting out of debt and stuff. This isn't the same, but it is sometimes, because some people get into a lot of debt. They live off of a credit card while they're not able to work when they're fighting a case. And it can be really bad. Sometimes they don't prioritize enough and they're going to lose their house because they go into foreclosure. And I hate when I see that happen, because why didn't you just sell, take the equity, and get something affordable within your means? And some people cannot do that. Some people don't have a house to do that with. They just have to live in an apartment. I would say too, sometimes people go, if they're, let's say, if they're like a single person, always paid, had a good job, paying their own rent and this part. Sometimes they go and live with family. What am I hearing out there? And it's temporary. It can be temporary. And then when they prevail, they, make sure they have a down payment or deposit if they're going to rent someplace within their means. Sometimes people move from a expensive area in the country to a less expensive area in the country. A small, more rural town that's not so high end. Some people are like, no, I refuse to move out of Bel Air. This is my home. I've lived here in this mansion forever. And then sometimes they're the ones that pay the price because they're going to lose the whole ship. So tough decisions have to be made. I was just before this, I had a meeting with my first time I've ever had a financial advisor in my life for the last 5 years, and helped me get from, where we weren't where we needed to be, and, all that. And, I'm old enough where I'm breathing down retirement. I plan on doing this for another probably 12 years or something, but it's still approaching the 60s. And that, but for his guidance, we end up now paying for, we wouldn't be where we are. It was even just the things about, it wasn't really about budgeting down. He never went into that stuff, but it was about forced savings. Just make savings one of your bills and it's over there. So regardless, you don't even know, you don't see it because it's automatic. So you're not paying a bill per se. Those dogs are being very crazy out there. Anyway, that's a whole, we could go on. We could have a special whole chat about that, couldn't we? Ways to cut down. But there are so many programs out there that I think can show people what to look at to trim. I mean, I should still be doing it because I know I have subscriptions that I should be getting rid of, and I don't even know what they are. But sometimes you get automatic. We found out about 2 weeks ago, somehow without us knowing, so we pressed on something and didn't see the fine print or whatever. We had like 7 subscriptions that came about through Amazon Prime, I think. Like, what's that one? You know, those movie networks, Paramount. I kept seeing it when we go into Prime, and I said, well, it's there. They must provide that for free as part of one of the. No, we were paying like $100 a month in subscriptions. We didn't even know we're a subscription. It's bad. So I know we have more to go in that, but that's ludicrous. Ludicrous. Gilmar says, I don't know what that means. Manage with caution. Yeah. Mark is in the house. Mark B. I don't think we've met Mark. I applied for SSI and SSDI in 2023, was denied, but won the case. Okay, so you were denied, appealed, won the case. But was just a couple credits short of SSDI. But now suddenly SSA wants new SSDI application. Are you working part-time? I don't even know what to say. I mean, did SSI call you out of the blue and be like, we want you to apply for SSDI? I don't really know what's going on. Was awarded SSI. I'm wondering why they would do that. Did they find new credits? Have you worked? I'd love to see you on SSDI instead of SSI. Yeah. God, there's so much more freedoms to be on SSDI instead of SSI. I mean, SSDI people probably complain because they're worried about CDRs. That's the only thing they got to worry about. SSI people have to worry about everything. If someone gives me $500 for Christmas, oh my God, do I have to report it? You know? And I can't inherit. And I don't dare play the lottery because I cannot lose my Medicaid and my SSI. You know? So SSDI is better. Plus you get the Medicare. And then you have that thumb off your neck. You could marry a rich person, inherit $1 million. You can do so many things. All right. I don't know why that's happening, Mark, but if you were working a little bit, that would explain it. It seems like a long time, a little late in the day for them to find credits, you know? Angela. Oh, Angel. Hi, Angel. I don't think we met. Hi, I'm Angela. I have CDR review for my SSI in March. Okay. I just talked to them a couple of weeks ago. I added my grandbaby living with me, so I'm unsure what the second would be about. CDR has to do with your disability, not your finances. Generally, you said SSI, so that means yeah, people that live in your house can be relevant. So you're 50, you've been on SSI since you were 39. You were not on Social Security, so you didn't pay in enough to get SSD during your non-disabled years. I don't know. CDR, everyone has to go through CDR. Is that your first one? They want to see if you're still disabled. I mean, on the positive note, Angela, you're over 50. So unless your physical problems all disappeared, and unless it's totally mental, you have at least the grid rule in your favor, you know? So Mole says, hey, Walter will love you. He has dogs too. Walter, not. He has dogs too. To SSA lawyers. Oh, you're married. I live in West Virginia. Yeah, I'm married. I'm happily married. But all good. James is in the house. Nice to see you, James. Well, I'm off to see the district federal judge to challenge the SSA pencil whooping my decision. Okay. Good day, everyone. Good to see you, James. Pencil whooping. You're welcome, Sarah. Jen Me says, my therapist and I talked about this one by one at length. One of the 4 or 5 criteria to say if you can do each of these things as a sustained basis, and basically can't do anything on sustained. Yes, but there can be I can't do it on a sustained basis for 8 hours, but I can do it for 4. I can't speak to your specifics, but I'm just telling you generally. I understood what your lawyer was saying when what the SSA is going to say when something says all the severe, And then your therapist's notes do not speak to all those things being severe. Her real-time notes. So suddenly her notes are inconsistent. I'm just saying that's something that could have happened, you know, because her notes better back up her opinion when she put severe on everything. And so many times therapists will be like, doing good, because it's like a pat on the back, because my therapy's so darn good, or because their boss. There are definitely something to the phenomenon that therapists, if they work for somebody else, are often required to show that it's helping. I feel like there is a smart way to do that without sabotaging someone's case, but they're maybe not that sharp. But they have to talk about how good it's going, or else maybe they get funding cut. Well, if you're not helping, why are we still funding you? I don't know. It's usually everything comes down to the money, though. So therapy notes are often, particularly for someone who's not independent and able to say what they want to say, are often not that great. Yeah, Jen, I get what you're saying, but do you get what I'm saying? If you're looking at just one thing, you're going to miss all the other things that actually feed into the whole totality of those circumstances and legal rules. Sherry Romero says, yes, I do have a representative, but thanks. I have the hearing in June. Just wanted to know if you thought I had a good chance of winning. Your age is a detriment, but you have a representative. That's a positive, because that makes me know that they're probably organizing your medical evidence. It sounds like you have good evidence. Like if someone in the harder age range had your stuff, that would be the kind of case that someone might be willing to go out on a limb for. So that's my point, because it sounds like you've got it so bad, my dear. And I'm so glad you have a representative, because it just seems better. It just seems like there's more evidence to be had. They and they can make the legal arguments so that the judge definitely doesn't miss, because the judge is never going to know the case like we do. There's just no way. So sometimes you just want to, point out. So we do the briefs, point out the things that would be legally implicating that are, hidden in the records. But we go through the records word by word. So as long as we can read them. Oh, Siren says, I meant over the phone after the hearing. Sorry. Some do, some don't. I do. I always do. But, we're always in such a, even though we don't do a lot of phone talk during the whole workup of the case, it's more messaging, because we're going to be in person at the hearing, and we do it phone trial hearing prep, like a day to a few days before the hearing, and that's usually a few hours. By then, we're like, I don't know. It's kind of like being in a trauma situation with a stranger. You become fast friends. So we kind of have that thing that bonds us kind of towards the end. To whatever extent we didn't bond, the same degree through messaging and stuff. And then, yeah, I would always just call him. Just, if I think it was very clear we won because of things the judge said, I'll tell them that. And I'll say, but we don't really know until the fat lady sings and we get that decision in hand. I'll be done in a minute. Maya, wait. Sorry, that's the Bernese. She just knocked on my glass door. She breaks so much stuff. She's like a big bullet. I'll be out in a minute. No potty till I get out. We are way over time. It's 2.5 hours. All right, let's see if I can blow through this now. Yeah, so I do. I always call my people, but I don't know that everybody else does that. Jenny, and it's proven even by medical records, as you know, I can communicate with anyone if I'm in the hospital. You mean you can't communicate with anyone if I'm in the hospital in treatment because my conditions are so bad, especially if you add more stressors. I understand, and I have hopes that you're going to overturn this. So, your case better. I am glad you have the attorney, though, because she's pointing out the weaknesses. So obviously there are weaknesses, or the judge wouldn't have gone the way they went, even if the judge was mistaken to go that way. You follow what I'm saying? So if we can get rid of those weaknesses, the whole point is getting you to win. It doesn't have to be, only this way do we want the win. No, we just want the win. I got what you said. Yeah, I knew what you were saying, Jen. You can't communicate when you're in the hospital. Yeah. Yeah, and you know, as we've said before, if someone's getting psychiatrically admitted twice a year for not for 3 days, um, but with an involuntary or longer few months, twice a year is I can't imagine that being a lost case. I don't know if you need it that much, but something like that, even maybe even once a year if it's pretty long. Because let's face it, when you're out of the hospital, it's not like you're suddenly perfect, and everything, all the impairments are gone. Cly is in the house. I don't think we've met. Cly says, I am 32. Never been able to work because of health. Always lived with and financially supported by parents, but need financial assistance now. Could I be approved for disability, never having worked? For SSI, yes. Or if you can prove that you were disabled before age 22, you might be eligible for DAC benefits on one of your parents' work records, if either one of them are claiming or will claim in the future. So definitely save all your old stuff, because you might not be able to apply for DAC now because your parents are not collecting. No one's passed, no one's disabled, no one's retired. But one day they will be old enough to collect. And then you, even if you're on SSI, at 45 years old, even you could change up to so you don't have your own work record, but you might be able to go up your parents, but you have to prove that you were disabled before the age of 22 and that continued ever since, and you can't be married unless it's to another DAC person or possibly another disabled person. No, I'm not sure it has to be a DAC person. So yeah, for sure. You've never applied? Oh my gosh. It's a shame that you didn't apply before. I would I mean, you never even applied, you never even worked part-time. So then you're severely disabled, or would you have been able to pull up part-time, but you had your parents supporting you, so you didn't do it? I mean, one way or the other, right? But yeah, you can definitely apply if you think you're disabled from working. And you only have to be disabled from working full-time, Claude. You don't have to be disabled from doing a very part-time job that a disabled person can do. So you can still earn money. Chedney says, if someone moves, they should move to a jurisdiction with good ALJ approval ratings. There's a point to that. Although the funny thing is that they switch them up now. Sometimes, like I was saying, I had a hearing in Connecticut and my judge was in Puerto Rico and the person was in Connecticut. I think that's because my person was Spanish speaking, but that was a young person. That was a long time ago. That was over 10 years ago. James says, my doctor literally documented that I should be limited to sedentary work in 2023, and yet not a mention from the ALJ and basically not considered at the appeals council. SSA equals a box of chocolates. Well, that's because your doctor screwed up a little bit. He was suddenly trying to be a vocational expert and saying sedentary, when does he even know what sedentary means under the SSA rules? Perhaps what he should have said was a little more specifically, for medical reasons, it would be unsafe for him to be on his feet more than 2 hours out of an 8-hour day. He should be sitting most of the day, or it's not safe for him, and or he would not be able to do it reliably to lift more than 9-10 pounds at all. Those are things. But when he's trying to pull out the definitions of sedentary, this and that. Secondly, I forget your vocational profile, James, but limiting you to sedentary still means you can do work. So did limiting you to sedentary, would that have, if believed by the judge, would that have gotten you disability benefits when it's saying you can do sedentary work? That would come down to your vocational profile, and I don't recall what that was. Hey, Aunt Lizzie's in the house. I'm questioning the training expertise of the people who make decisions about disability regarding SSI with FAS. What's FAS? I don't know. They're not doctors, so by sure you should question. Are they trained in the laws of SSA? Yes, they are. And there is a doctor who is a medical doctor who generally does the RFC decision. So you could question whether a doctor is a doctor, or question whether he's a good doctor. But he is an MD, or potentially a DO, I think. So yeah, they got the credentials. Doesn't mean they necessarily do a top job. Soul Sucking World. Hi there, Soul. Hi, Miss Joy. Can you take my disability case? How do I go about it? That I wouldn't know. You'd have to go through our evaluation process, which, by the way, if you see the scrolling little thing on the bottom, it tells you to go to the website. I would say look in the upper left. You're going to see a link for a free evaluation, Soul, and we can take a look. All right. And if we can't, you'll be learning soon enough. We'll let you know that there's no opening in that particular category that you have. But that helps us figure that out so we can get back to you. My audio is good. Thank you. Mark says, no work, but felt weird. They're giving little to no info. Yeah, that is weird. Interesting. That is interesting. And you won a long time ago. You didn't win back. You didn't win now with an onset of 23, right? You've been on SSI for 2-3 years, and then suddenly they said file for SSD. Go ahead and download your annual earnings statement, Mark. And see if there's any like earnings popping up in 22, 23, 24 that wasn't there before. Maybe do have more credits. I would find it weird that they would be doing a retro long after the fact of, you know, I don't know, like a quality review much later. All right. 3D says, before my condition got worse, I was a college student and lost my benefits. Okay. Why'd you lose your benefits? So you were over 18, and you were on SSI, went to college, and then you lost. It's probably because they found that you were medically improved, I'm guessing. I had been relying on SSI and FAFSA student loans to support myself while in school. When my health declined, I couldn't even keep with basic things like my phone bill or fixing my car. Now I depend on odd jobs just to survive, while my disability case is still going through the process. It's humiliating at times. Yeah, I understand. I hope you have close family that supports you. The light's coming. It seems light out here and dark in here. Hey, Jennifer's in the house. Jennifer Cologne. Hi, Jennifer. Jennifer says, saw you were live and just wanted to say hello. Good to see you. Found out yesterday that I have a permanent spinal cord injury. I am very sorry about that. I have cervical myopathy from C3 to T1. I'm so happy I finally got SSDI. Me too. And I'm going to see your boy tonight doing a collaboration with Jonathan at, I guess, 8:45 on his live stream Q&A. So if you pop in, Jennifer, I will see you there. Thanks for saying hi. I appreciate it. She says, it's hard enough not being able to use my hands and arms much and hold my head up. Oh my gosh. But continuing to fight for SSDI would be too much. It is a stressful journey. It's amazing, isn't it? I mean, I suppose it's, well, that just makes it wonder. If I forget what year SSDI came out. Was it the 60s? Before that, was there less stress because there was no potential SSDI, so people didn't get stressed about it because it didn't exist? You know what I mean? I think back then, people's families, everyone was a little more cohesive. There wasn't this huge like rift on families and separation and, you know, not having close families anymore. And I just wonder, you know, people were just disabled and their families, everyone stuck together. That's the way it was. Now we don't see as much of that because families have kind of been on the, I don't know, self-destruction, I suppose, somehow. Just making it so far is in the house. Hi, and good to see you. I'm on the appeals council, and so he's at appeals council level. When I called the appeals council, they said my case was under evaluation. That means they're evaluating, and that means it sounds like you're not waiting in the bullpen for a panel to look at it. What does that mean? Also, I submitted a dire need. How do I make sure they mark my case as critical? Well, if they either believe your dire need and they do it or they don't, you can, when you called them, did you ask them if they had accepted it as a dire need case? I always say to just be careful what you wish for. Do you want them to rush? I would tend to think of rushing is more of a denial than an award, because a award has to be highly substantiated to not get audited. So Just be careful what you wish for. Not to say you shouldn't do dire if you have legitimate grounds, which would usually be like becoming homeless, not having family to live with, or going to lose, you're going to be foreclosed upon, that kind of thing. Just making it says, so sorry, I didn't even acknowledge you. How are you doing? You're here. That's an acknowledgement. Are you kidding? If you're talking to me, all good. Your mere presence. Cly says, thank you. I've always had a little self-employment income, online business, but very little income, not even close to full-time. Sick through my teens, but not functionally impaired till age 22. Oh, so you can't get that. That's unfortunate. But you should be able to get SSD, right? Because if you're reporting those earnings and not writing off everything to save on taxes, don't be so cheap with your tax. Oops. Oh, shit. Oh, no. Oh. Oh, my goodness. Did you guys see me go out? That was terrible. I went to change something and I pressed the off button. Oops. Sorry. I hope we're all still on. Looks like we're at the last question anyway, right? Aunt Lizzie says, how do I request them to hurry? We are borrowing money to care for disabled son. That using your money to pay for other things might not be the kind of dire that they need. I don't know. There is a list of dire reasons. So you'll have to talk to them about that. I mean, your disabled son should have his own income, SSI, so it shouldn't really be you borrowing money to care for him. You know what I'm saying? In a sense, I know we all do whatever we can for our children, but usually, if it's a child, is it a child? Because they get a lot of. Usually, there's quite a bit of benefits. And is someone staying home with him so that you don't need to pay a caretaker, that kind of thing? Shiloh says no. All right, so we're good, right, guys? I think that's all the questions we have. He's 18. So, right? Aunt Lizzie, disabled son. Is that who we've been talking about? I know you've been here before, but I don't recall the details. They don't understand FAFSA. You mean FAFSA? What is FAFSA? They don't have to. They have their rules. If you're talking about the SSI people, they just have to follow the rules that they're set by. They don't have to understand anybody else's program. It's what their rules say. Anyway, I think we're at the end, guys. We've been going almost 3 hours. If anybody has more questions, you can always post them under any video, even if it's not related to the video. So if you go to any 12 o'clock daily video, say hi is always nice. But if you have a question, if it's suitable for a video, I will pop it into video. If not, I'll try to answer it real quick, right there, if that's appropriate. And anyway, if you want to come visit tonight, I'm with Jonathan Ginsburg at 8:45 on his live stream channel. I think you guys are mostly familiar with him. He's like the grandpapa of SSD live streaming. All right, so have a great week, guys. I hope I'll see you next Wednesday, 1 p.m. Eastern Standard Time. So bring your questions, of course. Spread the word. Like, share, and subscribe, like they say. And I hope to see you also at the 12 o'clocks, with your comments, questions, and any need or thought to a video that's doable without me having to take a lot of time off of work to try to organize it. That would be great. That's why it's usually just the off-the-cuff things that come up in the work day. Right now, I'm kind of focusing on function report stuff because a lot of people have to do their function reports, not just before or during their initial, but also on reconsideration and all the ways that they can make sure those are not going to sink their ship and can be a positive little nugget of information for the judge who wants to award you later to pull in and apply in his decision, because they'll use that sometimes as a nuggets to support their medical finding of disabled. So, all right, guys, just gonna do a quick scan down real quick. I think we're good. Yes, we are. All right. Thanks, guys. Have a great week. Be safe and God bless. Bye-bye now.